Sakis and Mr. Fallon, if you could all please come up. There may not be enough chairs. Is there? Yeah, there are. Perfect. And of course, Madam Secretary, and well, acting for a very hopefully short amount of time, Madam Secretary, if you'd like to begin, and then each of your panelists make sure that they at least introduce themselves before they begin. Ma'am, go ahead.
Thank you. Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the committee. For the record, I'm Acting Secretary of Labor, Portia Wu, here to present House Bill 548, the Access to Banking Act, which is one of the key pillars of the governor's legislative package for this session. As you know, Maryland is home to some of the richest communities in the nation, but also to some of the poorest. Our state is rich with opportunity, but those opportunities are not equally distributed among individuals and small businesses in our communities. We need your support to unleash the potential of Marylanders in every zip code by providing access to banking products and services so they can compete, thrive, and contribute to the growth of our economy. According to a study from the U.S. Senate Finance Committee, Banking Committee, access to capital at reasonable rates remains the biggest challenge to minority business success. Black entrepreneurs trying to start a business are 58% more likely to face a credit gap compared to 32% of white entrepreneurs. The Access to Banking Act would ensure that Maryland banks remain in low to moderate income communities. This legislation seeks to improve access to banking for both individuals and businesses. The bill would accomplish this in two ways. First, it creates an assessment credit for licensed banks or credit unions located in low to moderate income areas. This credit will help to reduce the cost of institutions located in these areas as it creates community stability and increased investment in both individuals and companies. In addition, the Act establishes the Community Investment Venture Fund to leverage public and private dollars to expand access to capital for small and micro businesses that may not qualify for traditional loans. Small businesses thrive in places, therefore, where people can live, work, and prosper. The premise is that this fund will invest in developing products and services that will provide flexible and alternative lending data points or requirements that are necessary to underwrite a loan. Many existing and potential businesses in low to moderate income communities lack access to capital because they simply can't provide these strict data points or requirements to a potential lender. This fund will help develop, test, and make available these products and services to lenders so that investment is expanded. I'm asking this committee for a favorable report on House Bill 548. I will now turn to our Commissioner of Financial Regulation, Tony Salazar, who will go into greater detail on the operational components of the bill.
Thank you, Secretary Wu. Good afternoon, Chair Wilson, Vice Chair Crosby, distinguished members of the committee. For the record, I'm Tony Salazar, Commissioner of Financial Regulation, and I want to thank the Secretary for introducing HB 548. I'll provide additional detail and also ask for a favorable report. So, as the Secretary mentioned, the bill is intended to encourage access to banking and investment in our state's economy. So the bill would change the assessment system for the depository institutions by providing an incentive for these institutions to not only establish new branches in low to moderate income areas, but to retain them. So each year, our office assesses each bank and credit union to cover the expenses of regulating their respective industry. Those funds are deposited into what we colloquially know as a depository fund. So this bill establishes an assessment credit for all the branches that the institutions currently have in existing low to moderate income communities and for their any branches that they establish for the next period of 5 years. So all that is with the intent to incentivize presence in the low to moderate income areas. Just some details. At the end of fiscal year 22, the depository fund balance was approximately $9.9 million, which is approximately 2.6 times our office's annual expenses. So the proposed credit, if fully utilized, we anticipate would cost about $250,000 on an annual basis. So while that's a reduction in revenue, the fund would still have sufficient resources to fund our office's activities, notwithstanding the credit usage. Secondly, as the Secretary mentioned, the bill authorizes OCFR to use some of the funds in the depository fund to seed this new venture fund. And it's designed to use those accumulated funds to foster financial innovation on the commercial end, to assist Maryland businesses in the low to moderate income communities to access capital. So the newly created fund is intended to invest in fintechs, which are financial technology companies, as the Secretary said, to develop new data points and find new ways to use existing data points. The fund will be authorized to make these products available to the banks and credit unions, and to encourage them, the depository fund will match up to the amount of credit they receive any investments that they make. So the intent of the fund is to find fintech companies, excuse me, one sentence.
You're almost done?
Last sentence.
Outstanding.
So I just want to point out that the intent of the fund is to develop products in the commercial lending area in low to moderate income areas, just like the fintechs have done for the consumers. Thank you. Sorry for going long.
Thank you, Mr. Chairman. Good afternoon, Chairman Wilson, Vice Chairman Crosby, members of the Economic Matters Committee. My name is Ramon Luby. I'm the President and CEO of the Maryland Bankers Association. It's my pleasure to be with you here today. I want to thank the Secretary and the Commissioner for asking me to be here with them. Founded in 1896, the MBA represents FDIC-insured community, regional, and national banks that operate here in our state. MBA members operate more than 1,300 branches and employ more than 30,000 bankers across Maryland. Today, I'm here to offer MBA support for House Bill 548, which authorizes the Commissioner of Financial Regulation to establish the Community Investment Venture Fund, which you've heard from the Commissioner on this. This fund, as you've heard, will develop opportunities, including funding for certain initiatives, advancements to assist banks in serving low and moderate income communities. The bill also establishes incentives for Maryland chartered institutions in the form of assessment offsets, credits for branches located in low and moderate income census tracts in the state. Our members are partners in their local communities and economies and invested in the economic growth therein. Health and vitality of these communities are paramount for our members. Consumers' needs and preferences drive the direction of the banking industry, and banks are committed to meeting those needs. Banks remain eager to ensure that all Marylanders have access to safe, affordable financial products and services that help them achieve their financial goals. And with that, I ask the committee for a favorable report on House Bill 548.
Good afternoon, Chairman Wilson, Vice Chairman Crosby, and members of the committee. I'm John Bratsakis, President and CEO of the Maryland and DC Credit Union Association, where we represent over 70 not-for-profit financial cooperatives and their 1.9 million members. I'm here to testify in support of Bill 548. I'd first like to congratulate Secretary Wu and thank her and the Commissioner for their work, and we look forward to working with them in the future. Credit unions are member-owned, not-for-profit financial cooperatives. Their mission and purpose is to promote thrift among their members and create a source of credit for provident and productive purposes. Because of their mission and structure and purpose, credit unions, their members, are often the most hardest to reach and the most in need. And in fact, the majority of credit unions are headquartered in Maryland are low-income designated, meaning over 50% of their members are in low-income areas as designated by the census. They are the same communities the bill aims to serve. We are happy with the administration's focus on achieving these goals. The bill will also foster collaboration between the government, credit unions, banks, and fintech companies, while protecting consumers through a safe and sound regulatory framework. The consumer protection aspect is important and is often regulated through safe and sound framework. The consumer protection aspect is important as often regulated financial institutions are put at a disadvantage as fintech companies enter the marketplace with little or no regulation, and often consumers are left paying the cost for that lack of oversight. This bill will help ensure that that does not happen. Our members look forward to engaging with the administration and the department as this bill moves forward and ask for a favorable review. Thank you.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, my name is Brad Fallon. I'm a Deputy Legislative Officer with the Office of Governor Wes Moore. The committee, or the panel here, already just went over the aspects of the bill, so I'm really just here to answer any questions that any members of the committee may have. So thanks so much.
Thank you very much. See, one, I do have a question before Delegate Charkoudian gets to go on her tirade, brief tirade. But my question really does to one part of this issue, and it's been brought to our attention that there's been is my vision bad or am I blurry? All right, Hunter? So it's been brought to my attention that that as far as the physical banking, that is not as much in need. Now, granted, we're hearing, I guess, living in the tension of these two realities of most folks like myself. I've had a checkbook, the same one for the last 15 years probably, because we don't do a lot of checks anymore. There's not a lot of physical banking being done. So in light of that, with technology, banking by phone, how do you balance that out with the goals of trying to get physical locations into these impoverished and low-income areas? Brad?
Yeah, and I appreciate the question because it's a great question. We're working with the commissioner and with the secretary and private partners to look deeper into exactly what you just talked about, which is what are the actual root causes of banking deserts? Why are businesses and why are people unbanked? What we do know is that banks located and credit unions located in LMI communities do tend to engage more with the businesses and individuals in those communities, right? So this is a fairly low-cost way. You'll see in the fiscal note, it only costs us about $300,000 a year to make sure that we're helping the bottom lines, those de novo branches or branches that are already located in those communities. I think the broader part of the bill, though, the Maryland Community Venture Investment Fund, it speaks not to the physical location, right? But speaks to kind of the digital economy that you're speaking to, which is, look, these people are unbanked. It might not be because their store isn't located next to a bank, but regardless, they're unbanked, right? So it might be because they don't have the underlying data points necessary to underwrite a loan. And through kind of government funding and partnerships with the private sector, with fintech companies, and with our banks and credit unions, we can come in and make technology available to them to ensure that they are at least able to present the data necessary for a lender to review the loan and potentially approve it.
Thank you. That's what I really wanted to get to the root. It's not just about the physical location of the bank. Delegate Charkoudian.
Thank you, Mr. Chair, and thank you all for your work on this bill and really trying to get at a crucial issue in our communities. You were the gentleman from the credit union, and I forgot your name.
John.
Yeah. Just at the end of your testimony, you mentioned something that I wanted to ask a little more about, which is sort of fintech products, and fintech products can be very beneficial to consumers and also can be problematic. And I just wanted to understand more about, I think what you were starting to talk about was the protections, and anyone could answer this, Bill, but you were getting at this question that I had, which is the protections in place and how are the pieces that are going to be supported by this legislation, how are we going to make sure that they are sort of purely beneficial without any of the problematic aspects that sometimes are there?
Sure. So what we've seen in several other iterations of a bill similar to this is that rarely are the regulated financial institutions included as a partner to collaborate with the commissioner in a regulatory framework. And that's really the difference in this bill. So we think that by working together and having that regulatory oversight, that there will be a way to help protect consumers and also do it in a safe and sound manner, which often there are times that fintechs will come in and being loosely regulated, they have an advantage to go after a community without really any oversight until it's too late.
Thank you. Mr. Chair, can I ask the commissioner or the secretary also to speak to that, if you would?
Sure, I can speak to that. So I think John hit the nail on its head when he said that we would have the commissioner and the bankers part of that. Now, don't forget, this is to encourage commercial aspects, right? So the consumer effect would be a little lower, but usually fintechs go in and they either don't have a lawyer, may not be aware of the complexities of the financial law. So having our office involved at the beginning and directing and working with these institutions is where we believe the benefit comes in.
Okay, yeah, no, and I've worked with a lot of smaller businesses who are newer and get caught up in scams, or even not a scam, but just something that isn't actually beneficial to them given their business structure. And so in thinking about going in and encouraging people to engage in the banking system and wanting to make sure that anything we're sort of subsidizing or supporting is definitely going to be beneficial to those small businesses. So just
If I may, Mr. Chair, just one other point on that. There is a requirement in the bill.
Was there a question posed? I don't know if there was a
Okay.
question posed. If there wasn't,
Just to elaborate on that, but no.
there sort of is. I'm just trying to figure out what the protections are.
okay.
I'm interested in Brad's
Go ahead, Brad.
perspective on that.
Just to quickly, there is a requirement in the bill that there's an annual third-party evaluation on the way that the fund is used. So there is a high level of scrutiny placed upon not just what these investments are being made in, but also how the fund is making available these technologies to banks and credit unions and small businesses. So with a high level of scrutiny and putting kind of a magnifying glass on it, that's part of the accountability measure.
Thank you very much. Thank you, Mr. Chair.
And again, definitely appreciate the question. That's important. I don't believe there are any other questions for this panel. I want to say thank you. And I believe we have Claudia Wilson-Randall and Robert Enton. Shocker. Mr. Stratton, you may begin.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. I did sign up. Mr. Luby, I think, expressed the sentiments of the Bankers Association, their support for this bill. I'd be happy to answer any questions that the committee might have.
See no questions, Bob. Thank you.
Thank you, sir.
Appreciate that. And I believe that concludes House Bill 548. And before we go on to our next bill, I would like all the individuals that are here representing the Jack and Jill program to please stand up. We have a lot of young students today observing our court. And, for those of you guys that don't know what Jack and Jill is, look it up. It's a great organization. All right, what we're going to do next, and please listen, we're going to be doing two bills simultaneously because the witness list is almost exactly the same. Delegate Love, I would ask that you come up. Do you have a panel, or are you good?
I do, sir. I do, sir.
And your panel is the same for both of them?
Not entirely. I didn't realize you were doing them both together.
We have all the unfavorables are just the same.
Yeah, I figured
You know,
they'd be
and
the
it's a
same.
very
So
similar
may I
subject
just
matter.
bring up the
So,
favorables?
if you'd like, look it up. It's a great organization. We're going to do, if you start with, outstanding.
How would you like me to proceed, sir? Just talk about both of them?
Whatever's your pleasure.
Okay.
You want to do the omnibus bill first, since that's pretty broad, or you want to do the narrow and broaden out?
Let me start with the narrow one, and then I'll just
Okay.
jump into the broad one.
No worries.
Thank you, sir. I appreciate that. Good afternoon, Chair Wilson, Vice Chair Crosby, members of Economic Matters. It's good to be with you today. I am Delegate Sarah Love, here to present to you two privacy bills. The first one of this is HB 33. Veterans of this committee will remember this bill. You have heard it before, and thanks to tremendous work by this committee, you passed it out last year, passed out of the House, and got stalled in the Senate. So I ask those of you veterans for a little bit of indulgence while I explain some things to some of the newer folks of this committee. So HB 33, excuse me for using this term, puts some guardrails around our biometric identifiers. So biometric identifiers are those unique characteristics like your fingerprint, your iris scan, your face print. And they're used for a lot of really great things. To open our phones, if you have that enabled, security on your computer, and many, many other things. However, you may be surprised to learn that there are no rules. Let me repeat, there are no rules on the collection and dissemination of these unique characteristics. Companies can and do collect, use, and disseminate these unique identifiers without our knowledge and without our consent. So what HB 33 does, it doesn't stop companies from legitimately collecting our identifiers. I want to make that very clear. It just sets some parameters. It says if you're going to collect these things, then I need to know about it. I need to consent. If you are going to collect them, you need to keep them secure. You need to have a retention and a destruction policy. And it also says that you cannot profit off of my unique identifiers. So why do I care? Why is this important? Well, first and foremost, there are privacy concerns. These are my identifiers. Secondly, once they're gone, they're gone. And they're not like a password that you can change. These are unique identifiers. And I've listed in my testimony a couple of really high-profile instances when these identifiers have gotten out there. Just last December, somebody bought on eBay for $68 a contraption that had over 2,000 individuals' biometrics. That, to me, is terrifying. So there are also well-known problems about bias in the facial recognition system. So all of that is in my written testimony. I ask you to look at it. I just also want to raise for you all that this is a really important topic that states are looking at. Right now, there are 3 states that have specific laws on biometric identifiers. There are 5 states that have comprehensive laws, which we'll get to momentarily. 9 states are looking at these biometric identifier laws. This is a hot topic. This is a really important topic. So I thank you all for your work last year, and I ask for a favorable report on this bill this year. Shall I go to the next one? All right, I promise to be quick. So HB 807, it may seem a little bit odd. This is a comprehensive bill. And what this bill is it takes the model of Connecticut. So I mentioned that 5 states already have comprehensive privacy protections on the books. Connecticut is really a national model. It was bipartisan. I believe it was unanimous, or at least nearly unanimous. So what 807 does is it takes Connecticut, but since Connecticut also encompassed biometrics, I folded in the bill that you all passed last year. So it's that biometrics piece plus the comprehensive piece. I just want to read a couple of opening sentences from an article from the Washington Post last week that really frames the issue to me. One company advertised the name and home addresses of people with depression, anxiety, post-traumatic stress, or bipolar disorder. Another sold a database featuring thousands of aggregated mental health records, starting at $275 per 1,000 quote-unquote ailment contacts. For years, data brokers have operated in a controversial corner of the internet economy, collecting and reselling Americans' personal information for government or commercial use, such as targeted ads. And it goes on. Right now, colleagues, we are the product. Our personal information is being taken without our knowledge and consent and sold, again, without our knowledge and consent. So there are a lot more things I could talk to you about, but I'll pass it on to the experts here. I'm happy to answer any questions. This is, like I said, a comprehensive bill that addresses our personal information and our sensitive information and just makes it clear that this is our information and we control what happens to it. With that, Mr. Chair, thank you so much, and I'm happy to take questions.
What's the, am I doing 2 minutes, 4 minutes? What am I? 2 minutes. Okay, so I'll try to get both in 2 minutes. I got you. I wanted to be clear. Okay. Good afternoon, Chair Wilson, Vice Chair Crosby, committee members. My name is Hannah Abrams, and I am an Assistant Attorney General in the Consumer Protection Division here on behalf of the Office of the Attorney General. I've testified here previously that our state needs a consumer privacy law to address unprecedented business practices of widespread personal data collection and distribution. To tackle this, the pressing issue, House Bill 807 takes a multi-pronged approach. It empowers consumers to control their personal information and gives consumers a choice. It requires companies to be transparent about their data collection and use practices, and it requires them to limit the data they collect. But as you'll see in my written testimony, there are a couple of elements that we recommend modifying. First, there are the exemptions. There are statutes that govern privacy, and Maryland's privacy bill does not need to supplant those other statutes, but there should be no sensitive information that falls in the cracks. There shouldn't be a gap between what HIPAA or the GLBA covers and what Maryland Privacy Act covers. If there are loopholes between, you end up rendering privacy meaningless. So the carve-out should only cover information that is covered by another statute to the extent it is collected pursuant to that other statute. Similarly, the exemptions to the definition of targeted advertising appear to limit very little in terms of actual targeted advertising. In terms of the biometrics elements, I'd also like to distinguish what Delegate Love has introduced from what you will hear happens in other states. There are two models in other states. Currently, either the law permits individuals to bring private actions, or the law only permits the Attorney General's office to bring the action. HB 33 provides a very limited individual action. It does not go through either model. It's kind of a straight in the middle. It only allows a private action if biometrics are sold, not if they're merely collected without consent, and the individual suffers harm. Okay, thank you. And we think that distinction is very important. We urge a favorable report on both of these because they allow both HB 807 and HB 33 because they provide consumer consent as well as enhancing data security. Biometrics are very unique, and the rest of the information is very sensitive. We urge a favorable report on both. Thank you.
All right. Thank you, Chair Wilson. Thank you, Chair Wilson, Vice Chair Crosby, and members of the committee. My name is Irene Lee, and I'm Policy Counsel for Common Sense Media, where I push for privacy and platform accountability legislation that will protect kids online. I'm here to strongly show my support for Delegate Love's HB 807. In particular, this bill would fill a gap in the Federal Children's Online Privacy Protection Act, or COPPA, by protecting teens aged 13 to 15 years old, which our research over the last decade has shown time and time again need protection too. If you ever wondered why your teenager may have some trouble thinking before they act on something, it's not simply because they're just being difficult. Our brains gradually develop as we go through adolescence. My written testimony explains in more detail, but the gist is this. As teens, the part of our brain that controls emotional responses, like our fight or flight response, grows faster and overpowers the part of our brain that controls higher level functions like planning, reasoning, and impulse control. Biologically, kids and teens are not yet as capable as adults of thinking through the long-term consequences of their actions, such as when they share their personal information online. And this makes them incredibly vulnerable to and defenseless against practices like targeted advertising and algorithmic recommendation of content. And online platforms amplify content incredibly detrimental to youth mental health, such as content promoting suicide, eating disorders, and dangerous challenges. And so HB 807 protects teens by requiring their opt-in consent before targeting them with ads or selling their data, and also requiring these notices to be simplified so they can actually give informed consent. And to make HB 807 even more effective, I strongly recommend amending the teens protection language so that a company shall not process the personal data of a consumer that they knew or should have known is a teen without their consent. This closes a loophole we see in federal COPPA that some companies exploit by turning a blind eye to young users on their platform in order to avoid compliance. We would also urge a targeted ad ban to minors altogether, a proposal we have seen get strong bipartisan support from Congress and President Biden. In conclusion, Maryland residents do not deserve to be left out of privacy protection simply because they do not live in a state like California that has a privacy law, and we urge the committee to move forward HB 807. Thank you.
Good afternoon. Chairman Wilson, Vice Chairman Crosby, members of the committee. Thank you for the opportunity to testify. So I'm Greg Von Lehman. I staff the Maryland Cybersecurity Council. This is a statutory body that is chaired by Attorney General Brown. Last summer, the council formed an ad hoc subcommittee on consumer and child privacy, 5 convenings over 6 months. I staffed that subcommittee, and I also produced the final subcommittee report. And I've been approved by the Office of the Attorney General in my staff role to urge a favorable consideration of the bill due to my involvement with the subcommittee. So just a few points about the bill, and I'm determined to beat the bill. First, what is the problem this bill is trying to solve? As someone with some background in cybersecurity, I look at this bill as an attempt to address the problem of risk management for the consumer. In our connected world, we're all more exposed than ever. Consumer profiles have hundreds of data points, and much of that information is extremely sensitive, and it's not pinned to a device, it's pinned to a known individual. Those profiles continue to grow in depth and sensitivity, as the delegate has mentioned, to include biometric data. And these data are shared widely across a vast ecosystem without the consumer's knowledge. So a huge risk connected with this accumulation, and there are many risks, but one of them is data breach and the spilling of all this information into the criminal market. Identity theft, extortion, sextortion, reputational damage are examples of the harms consumers are exposed to. So what's to be done? Well, what's to be done is to give consumers more tools to manage this exposure, give them more tools to protect themselves, and that's what this bill does. It puts more tools in the consumer's toolbox. So just 20 more seconds. Second, parents need help managing the risk to their children. Innovation has overtaken the Child Online Privacy Protection Act. Mobile devices means that a child can participate on platforms where they should not be, wherever they are, and without parental consent. Parents will say, and the ad hoc subcommittee report argues on the evidence, that a deeper partnership between these platforms and parents is needed. So the bill is commended for recognizing this. It does address some of the harms like targeted advertising, but particularly the bill is to be commended for calling for a task force to consider this question more extensively. I'd be happy to answer any questions. The subcommittee report was almost 40 pages. I couldn't get it in all here, but I do urge a favorable consideration of this bill. Thank you.
Good afternoon, Chair, members of the committee. My name is Marceline White. I'm the Executive Director of Economic Action Maryland, formerly Maryland Consumer Rights Coalition. We had a rebrand. And Economic Action Maryland advances economic rights, equity, and housing justice through research, education, direct service, and advocacy. We're here in strong support of House Bill 33 and House Bill 807. As Delegate Love said, you passed House Bill 33 last year, and we are in support of that, as well as the larger, broader bill of House Bill 807. My colleagues have already talked a lot about the bill and why it's important. I just want to make a few quick points. One is that this bill is critical because one of the things we see constantly is that technology is moving rapidly, and we don't always have the rules and regulations that keep up and keep pace with technology. And our fingerprints, our irises, our personal bodily identifiers are critically in need of protection. This bill asks for consent. It creates some clear guardrails. It has some clear exceptions for certain kinds of businesses, but we want to know how this data is being collected. We want to have consent over the use of that data, and we don't believe any, I believe no one should be making money off of that data, certainly without my consent. So I think for those reasons, it's critically important, and I urge a favorable report on both bills. Thank you.
I see a few questions. Delegate Queen.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this bill again to our committee. We've heard it a couple of times, as you mentioned.
But I want some clarity on the two different bills. So if we worked on HB 807, would we still need HB 33?
No.
Okay. So the second question, and this may be for you and the Office of Attorney General, I know one of the stumbling blocks we've had with some of the iterations of the bill is this difference between the private right of action or having the Attorney General address this issue. So we've gone back and forth. That's why you've seen it pass sometimes and not other times. But what I understand is at least the feeling of the last General Assembly, I don't know what might be today, is that the preference is to have the Office of Attorney General do it. If that is the way this body went, what would be your thoughts on that? We do not like the hybrid.
I'm sorry?
We don't like the hybrid.
You don't like the hybrid?
Correct.
Because that's what you all passed last
I know.
year. Okay. I understand. I hear you.
Thank you.
I like the hybrid.
I believe that's what this body and this committee passed last year. Am I correct?
Yes, sir.
Okay, thank you.
Yes, but the Senate did not.
Right. Well, the Senate,
But the question is,
okay, yes, sir. Yes, ma'am.
if it was all the Office of Attorney General, what would be your response to that?
Once I leave today, Madam Subcommittee Chair, the bill is in your hands. And if that is the will of the body, then that is the will of the body. I like it as it is, but it's your work product now.
Thank you. Thank you, Mr. Chairman. Good afternoon, Delegate Love. My question is, does this bring Maryland in compliance with the GDPR? Is that what these bills do?
So the GDPR actually is, it's fantastic. It really is.
I'm sorry, instead of using acronyms, could you please explain what that is?
It's Europe's version of Privacy Act.
It's
The General Data Protection Regulation.
Thank you. Thank you. I couldn't think of it. That, I believe, is broader than this and has some stronger protections, but it basically is similar.
Does your bill address who owns the data? Is it the individual ultimately that owns their data?
It doesn't specifically state that we own our data, but what it does do is make sure that we are the ones who control what happens to that data. So in essence, yes.
But it doesn't address who owns the data. So it's our data, someone else is using the data, but ultimately it doesn't belong to us. That's what GDPR does primarily. I mean, it's yours. So that's why I was asking the question.
Right. It doesn't.
Okay. Your bill applies to the private sector only. Does it apply to the Maryland state government and county units of government and townships?
No. This is
Why is that?
strictly, well, because there were other bills that were dealing with that previously, and so that's why I was focused on this, because that was a gap.
I haven't seen those bills. I've never seen a bill.
Most of those went to judiciary.
Judiciary, privacy bills for state government, for judiciary?
Well, because they were mostly dealing with law enforcement.
Okay. So, in other words, your bill, for example, there was a bill on the floor today, House Bill 86, that gives the state the right to turn over private taxpayer information companies to a private company. So state government, so your bill doesn't address that?
No, and honestly, Delegate, I was so happy to hear the things that you said on the floor. I found them interesting given that you had voted against my bills, so I was glad to see maybe you had a change of heart. But a lot of what you said, talking about the importance of protecting our data, is exactly what we're talking about here. So I'm hopeful that you will support this bill.
If you include government, I might, but thank you.
Sure.
Thank you, Mr. Chair, and thank you, Delegate Love, for bringing this bill forward. My question is for you or Mr. Kingman. I'm just trying to get some better understanding on how much this bill mirrors the Connecticut bill and understanding more so what consumer rights are offered in that Connecticut bill that we will now be getting and what consumer rights do we already have here in Maryland? Just trying to get a better understanding of the distinguishment and how the bill falls into your bill.
Sure. So Mr. Kingman is actually on the opposing side, so you can ask him that question as well. But I'm really glad you raised this question because right now, our rights are we get notification if there's a breach. Those are our rights. That's it. So what this says, 807, and it talks about we can confirm that what data a controller is processing of ours. We can correct inaccuracies. We can ask for it to be deleted. We can opt out of targeted advertising, sale, and profiling. There's also some limits in terms of what they can collect. It has to be adequate, relevant, and reasonably necessary for the purposes for which it's being collected. Let's see. There are a couple other things, but that's sort of the highlight of what our rights are.
Okay. Okay, that helps. Thank you.
Thank you very much. I do believe that that concludes this panel.
There are some more witnesses in favor and then
I'm going to call.
online. Okay, thank you, sir. Thank you all.
Ms. Karen Morgan. I believe we have, yes, and Michael Johansson. Ms. Morgan, you may begin.
Okay. Thank you, Mr. Chairman, Vice Chairman Crosby, members of the House Economic Matters Committee. For the record, my name is Karen Morgan. I'm a member of the Executive Council for AARP Maryland, and AARP Maryland is one of the largest member-based organizations in the state with nearly 850,000 members, and we're here to support House Bill 33 on biometric privacy. We think that House Bill 33 does a very good job of addressing the consequences that arise when entities collect biometric information. And we understand that businesses they can be whipsawed by technology as much as the average consumer because they're desperately trying, or the legitimate ones anyway, are desperately trying to make sure that they are actually dealing with who they think they are dealing with. And so they're collecting as much data as possible to verify that. And that's reasonable, but that's not an excuse to ride roughshod over consumers' privacy and their reasonable expectations. And from the consumer standpoint, these days, dealing with privacy looks like the Wild West, in that if you don't ask the right question in exactly the right way, in exactly the right time, then you risk having your private information exposed, and it's sort of like a gotcha because you didn't say it the right way and you didn't do it at the right time. This bill sets forth some common sense guidelines on what needs to happen when biometric data is collected, because it can't be changed, and it really is extremely sensitive, and that is not going to change. Biometric data is deserving of a gold standard when it comes to its collection, when it comes to its storage, when it comes to what happens with that data, whether it's deleted and how long it's deleted. As far as AARP Maryland is concerned, if you're in the data collection business, you're in the data protection business. So for that, we urge a favorable report on House Bill 33. Thank you.
But before we go to the favor with amendments, we do have one virtual. Marcus Roschecker.
Yes, thank you, Mr. Chair.
Thank you. Again.
My name is Marcus Roschecker. Mr. Chair, Mr. Vice Chair, members of the committee, thank you for this opportunity. I'm a cybersecurity and data privacy lawyer. I work at the University of Maryland Center for Health and Homeland Security, and I was also a member of the Maryland Cybersecurity Council ad hoc subcommittee on consumer privacy. And I do want to note that I'm offering these comments in my personal capacity. I just want to make 2 points about why I support House Bill 807. First, it provides Marylanders with an ability to make informed decisions about how their personal information is collected and used. And second, it asks the entities that collect Marylanders' personal information to implement reasonable security practices to protect that personal information and keep it confidential. We've heard about all of the ways that data is being collected about us already. And I think the point I'd like to make here is that Marylanders should have a choice with respect to how that personal information is collected and how it's used. To be fair, some individuals may or may not object to that collection, but some people do want more control over how that information is collected about them. And we should be giving Marylanders that choice and the opportunity to make that choice about how their information is used and collected. And the second big thing that House Bill 807 does is provide, quote, reasonable steps that entities would have to take to keep data secure and confidential. I think we're all of us are nowadays aware of how much of a threat cyber criminals pose. I think it's very reasonable to expect those who collect our sensitive information to be required to implement reasonable steps to protect that information and protect the confidentiality of that information. So for those two big reasons, I think, both of these reasons are very, very reasonable requests on the part of the bill. And for those reasons, I urge this committee to issue a favorable report. Thank you very much.
Thank you very much, sir. Seeing no questions, we'll move on to the next witness. We have one more virtual witness, Catriona Fitzgerald.
Hi, Chair Wilson and members of the committee. Thank you for the opportunity to testify today in support of House Bill 33 regarding the use of biometric identifiers. I'm Katrina Fitzgerald, Deputy Director at the Electronic Privacy Information Center, EPIC. EPIC has been a leading advocate for privacy for nearly 30 years. The owner of Madison Square Garden recently decided to use facial recognition to deny entry to concerts and sporting events to any employee of law firms engaged in litigation against him. He could choose to do the same to legislators who voted against his interests. A strong biometric privacy law can stop this and other abuses. House Bill 33 is based on the Illinois Biometric Information Privacy Act, or BIPA. And the most critical provision of BIPA and House Bill 33 is the private right of action that allows individuals to enforce their rights. But as a previous witness stated, it's limited in House Bill 33. I do urge the committee to return to the previous version of the private right of action that permitted citizens to enforce their rights in court without proving some form of personal injury. Injuries and privacy violations are real, but they're often very hard to prove to the degree of certainty that courts require. So I do respectfully request a favorable report, and I'd also like to speak on House Bill 807. House Bill 807 is a good start towards addressing the data privacy crisis we face, but there have been developments since Connecticut passed its law that present the committee with a better model to consider. Last year in Congress, bipartisan leaders in both the House and Senate proposed the American Data Privacy and Protection Act, or ADPA. ADPA went under extensive negotiations between members of Congress of both parties, as well as business and privacy advocates, received overwhelming bipartisan support in committee. It got a 53-2 vote. You don't see that in Congress too often. Unfortunately, they failed to enact it, but state legislators can now take advantage of the outcome of those negotiations. EPIC has converted the federal bill into a proposed state bill in order to provide that opportunity. And I've submitted the proposed bill as well as a bill summary and background information to the committee with my testimony. The bill's requirement that companies limit the amount of data they collect about us is what sets it apart from weak state privacy laws in states such as Virginia and Utah. Those laws were drafted by Amazon and do little to protect privacy. Maryland can and should do better, and ADPA provides that opportunity. So thank you. I'm happy to be a resource for the committee as it addresses this urgent issue.
Thank you very much, ma'am. I don't see any questions, so I appreciate your input. We now have Michael Johansson.
Thank you, Mr. Chairman. I'm Mike Johansson on behalf of Seaback Gaming, which operates as Horseshoe Casino in Baltimore. We appreciate the committee's work on the topic last year related to casinos' use of biometric data to prevent fraud and otherwise secure the important casino environment. The way the bill was amended last year and appears in this bill, it limits certain activity or exemption to only those people on the state voluntarily list. There are other people that are not on a voluntary list who, as casino past customers, we actually consider have committed fraud, and we may expel them from the property. So all we're suggesting in an amendment that I've submitted on behalf of the 6 casinos is that the casinos or any other licensee of the lottery, such as the sports wagering companies, follow all the same rules on biometric data, can't sell it, can't misuse it, have to post notice, but that an individual cannot request that their biometric data be removed from the casino database, and it doesn't automatically expire after 3 years. We're not trying to get any other exemption or any other, mishandling of data. We can't sell it or anything like that. With respect to House Bill 807, we don't have a position, but on the biometric piece of that, we would encourage the same amendment. Thank you.
See no questions. Thank you very much. I believe we have one more panel. These are unfavorables. Gregory McDonald, Bob Dean, and Andrea Mansfield. Mr. Dean, long time no see, sir. How you doing?
How are you, sir? Been a few years.
Been a few years, brother. And Officer McDonald as well.
Chairman?
It's been a while. Yes, sir. We used to serve together when I was in a different role, State's Attorney's Office. Bob was one of the deputies there.
Yes,
He
we
was just-
did.
This officer had a lot more hair and a lot less gray.
Well, Father Time never lost a battle.
Right. So go ahead. Who'd like to go first? Just
Great.
start
Actually,
by
Mr.
stating
Chairman,
your name.
I'll begin. Thank you, Mr. Chairman, members of the committee. Andrea Mansfield, here representing the Maryland Chiefs of Police Association and Maryland Sheriff's Association, and raising concerns with this bill as it's been drafted. And the major concerns here from law enforcement, and you're going to hear more details from the two gentlemen sitting next to me, is really that this legislation could prohibit the use of DNA and ancestry technology to solve difficult crimes. The way the bill is, the definition, the bill it does provide an exemption for state and local government agencies, but the definition of private entity does not include those entities that law enforcement may contract with. They actually do the matching of the DNA in that process. So we're concerned that we could kind of inadvertently get caught up in the language in the bill, and it would prevent them from solving these very difficult crimes that they do every day. Also wanted to point out in 2021, in your committee downstairs, the Judiciary Committee, we had a lot of conversation about the use of DNA and genealogical databases. Actually, this bill was about really 4 years in the making to come up with what we felt was a really good balance between protecting someone's privacy as well as providing law enforcement the ability to use this type of information. And so that bill passed in 2021. So really, I guess what we're asking here today is that and what you do with this bill, you do not, somehow you provide an exemption for those entities that they may contract with to provide for these matches and not do anything that would affect the process that we have in place under Title 17 of the criminal law article to allow for that use. And these gentlemen are very more knowledgeable in how all that works, and I'm going to let them speak next. So thank you.
Chairman and members of the committee, I'm First Sergeant Gregory McDonald with the Prince George's County Police Department. On behalf of Chief Malik Aziz, we're grateful for the opportunity to address you today to express our deep concern with the negative impact this bill, as it's written, will have on the field of forensic genetic genealogy in Maryland. I'd also like to publicly thank the family of Matthew Allen Mickens Murray, whose tragic murder was solved thanks to forensic genetic genealogy. I've been a police officer for 32 years, criminal investigator for the past 28 years, and assigned to the homicide unit for the past 24 years. Since 2015, overseeing the cold case homicide unit. Our team have fully embraced this new investigative tool, and particularly considering that a Department of Justice grant that was awarded to Prince George's County State's Attorney's Office for forensic genetic genealogy. Forensic genetic genealogy produces leads which law enforcement can then use to identify unknown suspects. The method can also assist in identifying unidentified human remains and the remains of homicide victims. Were this bill this bill before you today become law as it is now written, it would undoubtedly jeopardize leads developed from forensic genetic genealogy that would aid law enforcement in resolving unsolved homicides in our state. If forensic genetic genealogy is lost, any hopes of resolving unsolved homicides or identifying unidentified human remains will significantly diminish. There are thousands of unidentified DNA profiles from Maryland crime scenes that have been submitted to the National DNA Database, and after decades, no suspect match has been developed. If leads developed by forensic genetic genealogy are lost, investigators will have to revert to relying on unreliable jailhouse snitches, eyewitness identifications, and suspect confessions. And let me close by stating that we cannot afford to lose this groundbreaking investigative technique. Thank you.
Thank you, Mr. Chairman Wilson and members of the committee. I'm Robert Dean. I'm a Special Assistant State's Attorney in Prince George's County. I'm assigned exclusively to the cold case homicide unit, and I administer the $470,000 grant we received from the Department of Justice to utilize forensic genetic genealogy. Right, the concern that we have is that I don't think this bill in any way intended to disturb Maryland law enforcement to use forensic genetic genealogy. We've got 15 cases. We're soon going to have 20 cases where we're actively utilizing this process to solve old sex offenses and unsolved homicides. We want to nurture that process. We follow the rules set forth by the Department of Justice in their guidelines, and we also need to navigate Title 17 of the Criminal Procedure Code that has passed 2 years ago. We rely on databases that are held and managed by private entities. We rely on the processing of DNA profiles from private entities. I don't think you intended to sweep that into the coverage of House Bill 33 or even in 807. So I would urge you to consider some possible amendments that I've attached to my written testimony, and I'd be more than happy to discuss this further at any time that's convenient. But it would take away coverage of this act and its destruction protocols with regard to those databases that we rely upon that are held by private entities. Again, I have some options that I've attached to my written testimony that I would ask you to consider. I think that would solve the issue, and I don't think it would disturb the other intent of the coverage of House Bill 33, Senate Bill 169, and 807. So it's that particular area that we're concerned about. Thank you.
I do have a question or two,
Sure.
Bob. I'll start with you. So I want to make sure I understand that it sounds like there are two parts of this. One is obviously that you believe that the processes that are used, this would disturb the way the DNA is being processed.
Now, my concern is that these mandatory 3-year destruction protocols that are in both bills.
To go back, but that's, so let me step back. So you're saying that even in situations where somebody consents,
yes,
you think that certain businesses should be able to hold on to those for the lifetime,
yes,
a lifetime?
Yes.
In those businesses, is there any, you're not talking about, I guess we're trying, so you're saying the law enforcement, the entities you guys contract with that deal mainly in law enforcement, do they deal outside of law enforcement, these businesses you contract with?
I think they have specific contracts with regard to the databases that they're maintaining, where these are consensual DNA profiles that people submit. They know it's going to be used by law enforcement, and those databases are absolutely essential to our work. And the 3-year mandatory destruction that is embodied in House Bill 33 would, I think, basically Maryland won't be able to use the process.
No, I understand your point. I'm just trying to narrow down what it is that you're going to be asking. Obviously, you have it in your writings, but because this has nothing to do with those entities selling this information, right? It just has to do with.
That's not me.
That has to do with which you believe that the way they how do these entities get their database? How do they build it?
Basically, consumers will submit their DNA because they're curious about their ancestry. And Title 17 of the Maryland law says if they affirmatively opt in to having their DNA profile utilized and available for law enforcement, they can do that. And Title 17 covers that, so it's all voluntary. There are no time limits that Title 17 imposed. And there are 2 companies in particular that harvest. It's GEDmatch, GED Match, and
GEDmatch Pro.
And Family Tree. They have these databases. They're growing by the day. They're very useful because they are what we use for leads in our investigative process. And it's the destruction protocols of that biometric information that they have harvested, and they use it for law enforcement. That's what we're concerned with, Mr. Chair.
And that's why I guess I'm just trying to figure out what caveat you're trying to carve out. So basically, for the individuals that you feel conspicuously and knowingly allowed their data to be used by law enforcement, that law enforcement or the company that is contracted with law enforcement should be able to keep that, not sell it, not distribute it, but keep that for those purposes only.
Absolutely. And my suggested possible amendments for you all to consider, I have given an example from Illinois and their biometric privacy statute, as well as a couple options that I drafted up that reference Title 17, our own code, and the definitions in Title 17. And I'd be more than happy to work with you on that later.
Okay. Seeing no other questions? Well, my bad. Go ahead, Seth.
That's fine. You want to keep this data for law enforcement purposes?
Yes.
Why?
Because it helps solve unsolved murders and sex offenses.
And you know as well as I do that based off family and other genetic information provided by family who might consent, that you can build that profile without keeping this indefinitely. So you could have somebody that committed a crime leave bio material behind, and even though they're not part of this database, you can essentially locate that person, or at least to some degree locate that person based off other family members' information.
Build a family tree on publicly available information.
You want to keep all of that?
Yes.
Forever?
Well,
It's your testimony here.
Keep it until crime stops.
Thank you.
Thank you.
Yeah, thank you, Mr. Chair. How many more of these private companies could you possibly contract with over time? You mentioned 2. I'm assuming that you have 2. Could your list of private companies grow over time?
It could, conceivably.
And these companies then, how do we guarantee that they're only keeping that information for your purposes?
Well, that's part of the contract. It's for law enforcement. And these companies design their entire methodology for law enforcement purposes.
So these companies only do law enforcement?
Well, I can't speak to that. The part that we contract with is all law enforcement oriented.
So the question, I guess, that I'm getting to then is your contract may say that it's only for that, but how do we guarantee then that these companies are not doing something else? I think that's probably the biggest concern of many people with this. How do we know that these companies then are not, passing on that information to someone else? I mean, I understand what your purpose is, but how do we guarantee that they're not doing this, for something else to, make money or whatever the case may be?
I think they're making money because they're private entities, but law enforcement has engaged with our unit to develop, step 1 is to develop a DNA profile from the suspect sample that the offender left behind at the crime scene or on the victim. And that's called a SNP. We won't get into the great details, but then what they do is that SNP contains possible family relationship data, possible. And then they are uploaded, this reference, unknown forensic sample from the crime scene is uploaded into the 2 databases that are available now. And those databases are only used for this purpose, to see if there is a family relationship. It's oftentimes a fairly distant family relationship based upon aspects of the DNA profile that only show possible family relationship, doesn't show anything else. And then we have a second cousin or a third cousin, then it becomes building out the family tree.
Okay, the final question is, so am I then giving my biometric information to these companies that you're talking about, or are these companies getting my biometric information from Ancestry or 23andMe, those types?
No, they have to specifically opt in to that, the consumer who has submitted their DNA.
To whom?
To the companies that are harvesting.
Like the 23 and, okay,
Yeah.
that's what, okay,
Yeah.
thank you very much.
Thank you.
Ma'am, the only 2 companies we're allowed to.
You're fine. There's no question posed. Sergeant First, or Master Sergeant, what is it? I can't see from here. Sergeant First Class, Master Sergeant. What's your rank again, bud?
Sergeant.
I think you're like a corporal when we met, so I can't remember.
Yes.
But
It's been a long time.
It's a long time. So I guess we're all up here discussing because we've had bills like this in the past, trying to figure out. And to Delegate Harrison's question is, which is makes this bill all the more important, even if we were able to do the carve-out, is her concern is that 23andMe or they're purchasing biometric data from somebody else unknowingly that doesn't know that there's consent for law enforcement to use, because or these companies that you're using having some kind of verification that they're only getting the only data that they have on record is that which is being consented to, not additional data, because right now you can just go buy this information. And as you well know, the more information you have, the more viable your company, the more money you can make, the more it's helpful to you. So the concern with her, and this isn't yours, I believe, but is ensuring that the companies that you contract with are only utilizing data from individuals that have knowingly, allowed their data to be used by law enforcement.
That's, if I can just respond to that. Title 17 deals with that quite extensively, and we abide by that.
Okay, that's what we're going to discuss, obviously, in back room.
Thank you.
I do not see any other questions. Thank you guys very much.
Thank you, sir.
Thank you.
Yep, we can move on with the rest of the unfavorables. We have Andrew Kingman, Alexander Wallace, Andrew Mansfield, Jake Lestock, and Carlos Gutierrez. And Andrew Kingsman, Alexander Wallace, Jake Lestock, and Carlos Gutierrez. Go ahead, you can start by introducing yourself, sir.
Yeah, hi, good afternoon. Chair Wilson, Vice Chair Crosby, members of the committee. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a coalition of 30 members and 6 trade associations across a wide variety of economic sectors. While we do oppose both bills, our hope is that HB 807 can be amended to match the Connecticut framework that was enacted earlier in 2022. If it were amended, we would not oppose that version of the bill. We do oppose HB 33 in the current version because that language is based on, as prior witnesses have said, the Illinois Biometric statute. That statute was passed in 2008, just after the invention of the iPhone. It does not reflect the modern online ecosystem. It has been abused in that state via the private right of action, and this version would present real cybersecurity risks to consumers if it were passed in its current form. However, HB 807, as I mentioned, also contains language from the Connecticut framework, and we support strong protections for consumers' personal data. We believe that biometric information, among several other types of information, qualify as sensitive data and that they should be subject to opt-in consent requirements. However, the Connecticut framework that has passed in 4 other states does so in a way that also balances businesses' ability to implement the law and some of the cybersecurity concerns that I referenced earlier and that HB 33 and the current language in HB 807 present. I also think it's notable that in the last 15 years since the Illinois law's enactment, not a single state has replicated that model. Connecticut was the 4th state since 2021 to implement their framework. Thank you very much.
Sir, just quickly, you were a bit vague about the risk to consumers. What does this bill, House Bill 33, what are the risks to consumers with House Bill 33?
Yeah, sure. So one of the things, again, that the Connecticut framework does is provide a way for businesses to authenticate the consumer so that you can make sure that it's the person who's actually asking for that information. HB 33 also includes the concept of a third-party agent, the ability to designate somebody to act on your behalf. Again, the Connecticut framework requires the business and allows the business to make sure that that person has the authority to act on the consumer's behalf. This bill does not do that. And so it puts consumers at a great risk of identity theft and fraud for scams going to elderly folks saying, hey, I'll protect your biometric data if you give me the authority to act on your behalf, your social security number, your financial account numbers, et cetera. So there are safeguards, again, that are built into the Connecticut framework that are not present here.
It sounds like a simple solution, so if we were to add those safeguards in, would you be more supportive of the bill?
No, I wouldn't, because it still includes a private right of action.
Do you understand what the private right of action standard is in this bill?
Yes, I do understand
And you
that.
still oppose the fact that it has to be
Yes.
and
Yes, we do.
that's to be clear, you have to suffer harm, and so basically the way we let it out last year was that you had to sell it, and they had to suffer harm, and you oppose that. Why?
Well, first of all, again, the Connecticut framework, well, it also includes AG-only enforcement and the right to cure. It also provides greater protections for individuals with regard to their biometric data than HB 33 does.
But we're not comparing. But we're not.
I understand, but what I started to say was the private right of action, its existence will encourage frivolous litigation, and that's not hypothetical. In California, which does not have a private right of action for privacy violations, in the first 6 months of that bill's being in effect, over 50 class action lawsuits were filed trying to find a way of implementing a private right of action for that statute. These private rights
Were those successful, sir?
I'm sorry?
Were any of those successful?
No, they were not. But the point is that the lawsuits are brought not to bring any cases to trial, but to encourage and obtain settlements. And we've also seen in Illinois that out of the over 1,000 class action lawsuits that have been filed in the last 5 years alone, there have been 60 already filed this year. There were 16 filed in the last week. One single case has gone to trial. So again, that is not the purpose. That's not there to advance, case law or anything like that. It is there to extort businesses. We support attorney general enforcement and a right to cure. We think the goal of this should be compliance and not settlements.
If there was attorney general participation only, you would be supportive of the bill?
No, I wouldn't be, again, because it presents the security.
We already addressed that. But if I address those two things, you may be supportive, right?
I think HB 807 and the Connecticut framework is a better approach. I think it's going to
but
prevent.
we're not Connecticut.
Well, no, I
House
think
Bill
it presents
33.
more rights for consumers.
I was just saying, I was asking about House Bill 33, that if we clean up the consumer protection and the attorney general's participation, you would be more supportive of the bill?
No, again, we think 807 and the Connecticut framework is the way to go.
Thank you.
Thank you.
Go ahead, sir.
Mr. Chairman, Vice Chair, members of the committee, Colby Williams here with the Security Industry Association. We are the leading trade association representing companies providing a broad range of safety and security-focused products and services with over 1,300 member companies in the U.S., including 40 headquartered here in Maryland. We are concerned with this bill as it is currently written and believe it is the wrong approach to data privacy, as it would import an outdated and problematic model from Illinois from 2008, which is incompatible with the common frameworks that are emerging federally and nationwide. Safeguarding biometric information is important, but it should be done in a way that both protects your constituents and allows for the development and use of technologies that benefit and protect them. Beyond opening the door to lawsuit abuse through the private right of action, there are also very real consequences to consumers and their privacy for imposing unnecessary limits through overregulation. No other state has adopted legislation similar to the Illinois Biometric Information Protection Act, which has actually resulted in more harm for consumers and small businesses than protections. In fact, many of our member companies that provide products utilizing biometric technologies have chosen not to make these products available or the functions available in Illinois. Again, we support the overall goal of safeguarding biometric information, and we stand ready to provide any additional information to you and your staff throughout this process. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Jake Lestock, and I'm here today on behalf of CTIA, the trade association representing the wireless industry. And I'm here to discuss both of these bills. I'll start with HB 807 as it kind of includes HB 33. HB 807 looks to regulate various components of consumer privacy, including biometrics, differently than other comprehensive state laws. As currently drafted, CTIA opposes this bill. CTI members support strong consumer privacy protections, The stakes involved with the comprehensive privacy legislation are incredibly high, and a state-by-state approach on this important issue is going to lead to an unworkable patchwork that will also lead to consumer confusion. That's why CTIA supports ongoing efforts within the federal government to develop a uniform national approach to an inherently interstate issue. But while federal consumer privacy law is preferable, we understand that without congressional action, the states are going to act to fill that void. Deviating from clearly defined definitions, obligations, and privacy protections could have serious consequences on Maryland consumers, innovation, and competition in the state. We appreciate that HB 807 closely mirrors the Connecticut privacy law that was enacted last year. We believe that this law set forth strong consumer privacy rights and protections, imposes robust but clear obligations on businesses, and already addresses how businesses can use biometric data. By closely mirroring Connecticut, Maryland can ensure consistent privacy protections and help Maryland businesses with implementation. In order to achieve this, the added biometrics provision should be amended to better align with the state privacy laws that have already been enacted. And this biometrics provision, I would be echoing a lot of what my colleagues at the dais have said, would cause a lot of would cause to a myriad of issues. No state has enacted a law like that, and there's a reason for that. And the private right of action is inevitably a problem for us. So with that, we look forward to working with the sponsor to ensure that there is parity between state privacy laws. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Carlos Gutierrez. I'm the Vice President of State and Local Government Affairs for the Consumer Healthcare Products Association. Out of Washington, D.C., we represent the makers of over-the-counter medicine, dietary supplements, and consumer medical devices, and we are speaking opposed to 807. And our concern really is just how the bill interacts with the Controlled Substances Act of 1970, also the Combat Meth Epidemic Act, specifically transactions related to the sale of medications containing pseudoephedrine or ephedrine. Those of you who suffer from allergies, as I do this morning, you're used to the process of having to go to the pharmacy counter, present your ID, they take your name, the product that you're consuming, how much of it you're buying. And there are federal laws and state laws that govern how much of that you can buy. That's ultimately property of the retailer, and you can be denied sale. And that is governed by the Attorney General of the United States. We're just concerned that there isn't, that this bill isn't accounting for that data that's needing to be collected. And I have submitted written testimony on an amendment accounting for that. If that were adopted, we would go neutral. That's the only issue that or concern that we have. Thank you.
So is it your understanding that you believe that this, but you're not opposing House Bill 33, right?
No, sir.
Okay, you're fine.
Oh, that was me. Sorry.
Thank you, Mr. Chairman. I've heard frequently today about Connecticut being framework, and Mr. Kingman, you submitted a letter with several pages, but I was going to give you an opportunity because I know you described it as a sectoral approach in Connecticut, and I'm just trying to understand how biometric data is handled in that Connecticut privacy bill. If you can give me a little bit more detail about why you have your view.
Yeah, thanks for the opportunity. And I would say, you know, what we view as sectoral approaches would be regulating one type of information at a time. So biometric information has one set of regulations. Precise geolocation has another set of regulations. We think that the Connecticut framework is helpful because it regulates all of those types of information. So it classifies biometric data as sensitive data, along with health data, children's data, precise geolocation data. It establishes affirmative opt-in consent requirements for any collection or processing of biometric data. It requires the businesses to tell the consumer why they're collecting that data and the purposes that they're going to use that for. If either of those things change, they are required to go back to the consumer for opt-in consent. They also require businesses to document the processing of that data, to look through what the risks and harms of processing that data are and to document those, and then to document if they do identify risks, their plan to mitigate those risks. They also, to an earlier question about what the contractors are required to do, those are referred to as processors in this type of framework. Those processors are required to contractually agree to a duty of confidentiality with the data that they handle. They are required to delete or return at the controller's request all of the data to the controller once the contract is completed, and to allow the controller, so that would be the consumer-facing entity that's collecting that data, to conduct assessments of the processor's contractual compliance. They also provide the consumer with the right to access the data and to confirm whether the controller is processing that, to delete that data, to correct inaccurate data, to opt out of the sale of that data, the targeted advertising of that data, or to opt out of automated processing around that data as it relates to sort of important life events like insurance or education, things around that nature. It allows consumers to take their data that they've provided to the controller from one entity to another entity if they so wish. And so there's a really well thought out, very rigorous set of requirements and consumer protections there. The piece that is important as well is the enforcement piece. It has, along with every other state privacy law that has passed in the country, of the comprehensive nature here. It has the exclusive AG enforcement. It also has a right to cure. This is helpful for the business and the consumer and, frankly, the enforcement authority. It's helpful for the consumer.
I'm sorry, because I know we have 90-some odd witnesses. This might be a conversation offline because it sounds like we could go on for a little while.
Thank you.
Did you get at least the beginnings of an answer?
I did.
Thank you very much. Thank you very much, bud. The next we have is Carl Jackson.
Thank you, Mr. Chair. Mr. Kingman, how do the states that pass similar bills handle some of the concerns raised, like fraud and security exemptions?
Yeah, so there are protections. One of the things that I think is important and that our members believe is important in privacy legislation is not only enhance consumer control and transparency in the way that businesses interact, but also ensuring that businesses have the tools in their toolbox and keep the tools in their toolbox to identify fraudsters, cyber criminals, et cetera. This bill allows businesses to keep those tools in their toolbox by using whatever the state-of-the-art anti-fraud and cybercrime tools are. So, certainly we want to make sure, again, HB 33 does not have some of those protections in it, and we think it's important that businesses have those tools to make sure that their consumer data, employee data, et cetera, is protected.
Thank you. Thank you, Mr.
My
Chair.
question is to Mr. Gutierrez. The language I just looked at briefly is related to federal language about healthcare data. I'm assuming that's in other sort of state bills like this. Can you point me to where it's used other places at a state level?
Are you talking about HIPAA, the HIPAA language?
Yeah, the language you have in your amendment.
I see.
Yeah.
So we don't think we've been impacted by other data privacy bills that have passed. This is the first one where we have a little bit of a concern, and that's why we came forward with the amendment, just to account for the Controlled Substances Act.
Okay, because this was, that 807, I thought, was after Connecticut's pattern after their model, and you're saying Connecticut doesn't have anything that bothers you?
I'll double check for you to be sure. I don't think we had a problem with that bill, though.
Okay, thank you.
For this panel, so thank you very much. We can move along. The next panel is going to be Andrew Griffin, Kaylee Locklear, Paul Martino, and Kara Bender. Oh, no, I apologize. Kara Bender is virtual.
Thank you, Mr. Chairman, members of the committee. For the record, Andrew Griffin here on behalf of the Maryland Chamber of Commerce. In respectful opposition to both bills, I want to be mindful of the committee's time. You are aware of the broad business concern over the enforcement mechanism which exists in both bills. You know, the cost of defending the private right of action, the cost of settlements. Certainly there is no business size target in these bills, so this applies to both small, medium sized businesses as well. They can be quite significant, as you all know. Certainly the business community very much is reacting to the experience in other states. You know, the experience in Illinois, I think the worst case scenario would be, and you kind of heard an earlier panel talk about some of the concern with law enforcement, but that private entities begin to pull back on certain products and services that they offer as an unintended consequence of the bill, or begin to use less security and authentication processes, which are very common in other states because, again, as an unintended consequence of the bill. As far as we have implementation timeline concerns, those are all in my written remarks. We have concerns with 807 and lacking some of the policies we see in other states that have adopted these, like the right to cure. But with that, I will pause. I will urge an unfavorable report on both bills, knowing that, Mr. Chair, as you mentioned, there are concerns, but it looks as if there are paths forward here with some changes, and so we want to be part of that constructive dialogue. So I appreciate your time.
Andrew, I appreciate that because I think one of the concerns that I and some of my committee members have is that some of the consternation that's been expressed about this bill is nothing more than a dilatory tactic, meaning, hey, if it's not perfect, don't do anything. And I think that's the main worry. So I do appreciate your willingness to, because, you know, whenever we hear from the small retailers and the business community, we're always wondering what impact this is supposed to have to small business, because who collects biometric data on a small level? You know, things of that nature are of concern to the committee. But I do appreciate your understanding that we have to do something. And I think that's one of the things that I want everybody here to understand is our goal is to not do anything, and we cannot let perfection be the enemy of the good. We're listening to what everybody has to talk about. We're trying to do the best we can do in these set circumstances, but we can't wait another 3 to 5 years to figure this one out. And we have to move forward with something. So at the end of the day, I do appreciate that input and look forward to your input later.
Thank you, Mr. Chair.
Good afternoon, Mr. Chair, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Association. And I just want to say that because the retail market is one of the most competitive, successful retailers must earn the trust of their customers and provide privacy protections, and we do believe the Connecticut model comprehensively addresses many of these concerns. So with regard to HB 33, our organization continues to request a protective savings clause that has been included in every other state but Illinois. On page 6, lines 7 through 10, the bill states that a private entity may not charge different prices for goods if the individual exercises rights under the subtitle. Our customers voluntarily opt into loyalty, coupon, or rewards programs where they currently offer different rates or prices for goods. And in order to protect these programs, we are asking for the language from Connecticut and other states to be inserted into the bill. I don't have enough time to read that because I want to move over to 807, but I also just want to express our concerns with PRA and that bill too. The language in 807, should you not adopt the Connecticut model, also needs to be amended. That's section 14-4507 found on page 25, line 23G1, and then paragraph 2. Additional language was added to this, so it differs from other states, that is in direct opposition to Maryland consumer-specific and prior voluntary opt-in choices. Consumers would not expect a privacy-promoting web browser or other technology designed with signals to opt them out of targeted ads or data sales and then also opt them out of a loyalty program they already voluntarily opted into. So the inclusion of the text and those paragraphs upends consumers' choices. I do have our national expert with us who can answer more questions about this too.
And yes, Kayla, I have a question. I guess, what biometric data, we're on House Bill 33, what biometric data do your clients collect?
At this point in time, we do not, and I know we talked about this at length last year.
I think that was the concern about the, I don't understand what the opposition is when you guys don't fall under this bill by any stretch. And I know you have an expert, and maybe he could, expound upon this, because I am so confused here.
Thank you, Mr. Chairman. Happy to answer that. Do you want me to, well, I can give my other testimony after I answer the question.
No, you can go ahead and give your testimony. I'll reiterate the question once you're done if you'd like to. Go ahead.
Okay, sure. Well, why don't I do that real quickly? Thank you, Mr. Chairman, honorable members of the committee. I am Paul Martino. I'm the Vice President, Senior Policy Counsel for the National Retail Federation. Worked on these issues for many years. We support our state retail associations. I fully support the statement that Callie just made here on behalf of Maryland retailers. As she flagged, in each bill, there are problems related to customer loyalty programs. These are the most popular programs. Consumers, about 80% of all consumers participate in them. You likely all participate in one or more customer loyalty programs. The average adult participates in about 9 of them. The two issues that would not match, customer expectations. In the first bill, HB 33, it says that a consumer can exercise their rights under the bill, and if they do, they can't be offered a different price or service. That means that someone wants to, not opt in to any kind of loyalty program. That's fine, but it also then prevents other consumers from even participating in them. Because if she can't, if she opts out or doesn't participate in one, it prevents someone else from getting a discount. And so what other states have done with this language, in every state that's had language like this in HB 33, they've coupled it with a savings clause that says, businesses can still offer to other consumers loyalty programs as long as they have to opt into them and they're a bona fide loyalty program. We would recommend using the same language here in that savings clause. The other bill, 807, I'll just briefly mention, it goes even a step further. In a section unrelated to loyalty programs, it inappropriately includes language. The section's about having the ability for consumers to automatically be opted out of targeted ads or data sales. So they wouldn't be expecting that their web browser would then take them out of programs where they're earning points and earning discounts. And so we would also suggest in 807 removing that language that would automatically cancel their loyalty programs without their consent.
Could you please answer my question then? Because
Sure.
I guess, and I'll reiterate, I don't understand what any of my loyalty programs have to do with my thumbprint or my biometric data.
Okay. So I think the best way to answer your question is, of course, retailers are constantly exploring ways to provide innovative new services to consumers. You've probably seen some services like these. For example, there are pop-up stores now where you can buy goods without having to wait in a checkout line. Some of those, they give you the option as you enter to identify yourself. You can either scan a card, but they're also looking at other ways consumers might want to do that, such as by just putting a palm print down. It's faster, it's easier, it's more secure actually, and it can't be, it prevents fraud. And so what the bill would do in two respects in HB 33, in the first respect, there's language in 144503 section B1, that's on page 6, lines 3 through 6. It would say you can't offer any kind of new innovative service like that unless it's strictly necessary. Well, clearly consumers could use cards, but in other states, this may evolve to consumers using their palm print to pay for things, but they wouldn't be able to do it in Maryland. And so there's a concern there that the bill is sort of anti-innovation and that would prevent the development of technology that consumers may want to use. They would still be required by the bill to opt into it. They wouldn't be done without their knowledge or consent. But you are talking about something that would limit that capability. Likewise, if loyalty programs in the future were to, instead of having a card that you had to swipe or take out your phone and use a QR code to be scanned, if you could just put your palm down on a palm reader, you wouldn't be able to do that. So it's a question of convenience for consumers. They love these plans. In the future, what the bill would do would cut off that option to evolve programs in technological ways that actually benefit consumers while still giving them the choice to opt into it. So with the bill's protections, we don't understand why it would sort of cut off the ability to innovate in ways that they may want to participate in, may benefit them.
And I guess, again, so to my point, but currently, this bill doesn't affect any of your members.
I wouldn't say that for this reason. Which bill, first of all, are we talking
Let's
about?
go with 33.
So on 33, the problem here is that the language being used, this is how it would affect retailers. Without, every state that's had the language that I'm concerned with here on page 6 has coupled it with a savings clause to avoid unintended consequences. The unintended consequence here is that if one consumer exercises their right and says, I don't want to participate. Let's say a business wanted to offer, this ability, and but
they don't. What I don't understand is currently you keep talking about a what if in a possible future where people, and again, I'm horrified to think that it would be so willy-nilly that your palm print would be out to Safeway and everybody else to utilize or collect. That sounds like a horrible future. But under your example, that would be the future we're discussing, where I'm putting my palm print out. But that doesn't currently exist, nor is it, like currently, this doesn't affect your members.
So at recent trade show, for example, in January, this technology was being shown as, and all the technology being showed in this conference are technologies that could be made available within the next 5 years. So we're not talking about some futuristic
Sir, under that argument, virtual glasses could also, anything to do with regulating virtual eyewear, it's like anything could be used. I was trying to narrow this down to find out how we were causing any remote detriment to the retail agencies, because that is never our goal, and I'm not seeing it. But I understand.
Well, the bill uses non-standard language. It's like half a loaf. It has the prohibition on offering consumers, it says if one consumer says, I don't want to participate, it prevents other consumers from participating in loyalty programs. Other states have addressed that unintended consequence by putting the other half of the loaf in, which is a savings clause, which is very limited because it still requires consumers opt in to those programs. It's not an exception that is like a big hole. It just makes sure that one consumer's choice doesn't prevent other consumers from taking advantage of anything that the businesses want to offer.
Sure thing. Vice Chair Crosby.
Thank you, Mr. Chair. Just quickly, sir, you realize that if you sign and consent to this, you're not included, right? Because if the owner of the data provides consent, which when you sign up for, I don't know, last year the war on the floor seemed to be Starbucks loyalty programs for some odd reason. But when I sign up, I'm going to sign a waiver on the little screen when I sign up and put my number in there for that to link to my account. So I can consent to having my data done at that point in time or sold at that time. So
except the bill in this section actually prevents you from offering it. So in section 144503, page 6, between lines 3 and 10, on the first one, in paragraph B, it says you can't condition the provision of a service unless the biometric data is strictly necessary. Well, clearly, it wouldn't be necessary. It'd be an innovation that consumers may want to take advantage of.
But what sale are you conditioning that on? It's just a loyalty program. I don't have to sign up for the loyalty program to get my coffee.
When it depends what kind of loyalty program, but most loyalty programs, like in a grocery store or something, you get a club card.
Right.
Most loyalty programs you do sign because businesses offer them on an opt-in basis.
But I can still buy the groceries without the loyalty card.
You can, but then here's where the bill comes in on the second paragraph. It says you can't offer a different price to a consumer. So if you don't want to participate in the program, it prevents, let's say the chairman wants to participate in the program, it would prevent the chairman from even having the choice to do it. It would take away the choice because it says if one consumer doesn't participate, then no consumers can participate. It means in Maryland, you wouldn't be able to offer the same loyalty programs that you offer in DC, Virginia, elsewhere. So it really would disadvantage Maryland consumers.
And I don't want to keep kicking this horse, but the word conditional is important too, meaning if you're telling me the only way you can save money on coffee is to give me your biometric data, we're saying we don't like that. If you're saying, hey, you could use your thumbprint or a card, that's not conditional. If you allow, and innovation is what you were talking about, so I would assume the innovation would also allow things besides biometric data to be used for these memberships.
And I hear you, and I'm saying you wouldn't be able to offer consumers that choice. You would force them all to have to use the card all the time. Other states, consumers, because they have the savings clause language, innovation would be allowed to take place, and they'd be able to take advantage of these pop-up stores and arenas and other places.
Thank you.
So that's the concern. Is would Maryland consumers be treated differently? Connecticut and 4 other states have addressed this with the savings clause. We're just recommending putting in the savings clause language to allow Maryland consumers to benefit the same way.
Seth, go ahead, bud.
Thank you, Mr. Chair. Any concern about forced consent? I mean, I think the chairman was kind of getting to that, and I think the vice chair was kind of getting to that.
Yeah.
But on the opposite end of the spectrum where, you don't need my biometric data for coffee, but, I mean.
Well, I don't think you need, I guess,
And
I'm not
I
sure what you mean
agree
by
with
forced
him,
consent,
but-
because consent, the way it's defined in this bill and others, is a sort of autonomous choice on your own, after being informed, you make an actual choice, so no one's forcing you to.
Well, I guess,
sign up.
I guess the broader question, and maybe I'm off base, I don't know, is I'm concerned is that if you don't sign up for the loyalty program and you don't sign up for the biometrics, you don't get the groceries.
I think the bill prohibits that because you can't have any collection of biometric data without the opt-in consent in the first place. So where what I'm raising concerns with is language that actually goes beyond the basic point of the bill, which is that you must have an opt-in consent for use of biometric data. That's a general rule that exists in other state laws. It goes beyond that and says you can't even give consumers the choice whether to, use their biometric data or not use it. You can't give them that choice with the language that's in here now. And so we think there's some savings language that's pretty narrow. It's been used in 4 other states that can be inserted here to at least allow other consumers to have a choice. If you choose not to, that's fine, but then I can still provide that choice to other consumers.
Okay, thank you.
Get Adams.
Thank you, Chair. So I took some heat last year. I held this bill on second reader and had some amendments. So I'm going to do what I think the chairman would have asked me to do last year, which is if you got questions, do it in committee. Aside from the obvious sloppy wet kiss we're given to the trial attorneys on this bill, which I find it ends the conversation for a lot of us in the General Assembly. Okay, I'll say that to you. The bill, though, on this point with the innovation, two points, and they go to a question. One, I was at the hockey game last night, and at the hockey game was that venue you were talking about.
Yep.
You put your card in, and with at least 20 cameras, they're watching me go around the space. I grab a Michelob Ultra, I grab a bag of popcorn or a box of popcorn, and I come out, and I'm gone. I thought, from an innovation standpoint, it was cool, and I saw the future. Is this what you're talking about? Things that I don't even see.
Exactly. Pop-up store at Capital One Arena, where you walk in, you swipe a card. I think it's just a card at this point, or your phone, and then you can pick up anything you want and walk out. And it feels like you're stealing, but you're not, because it's keeping track of what you purchase.
So the only other thing I'll add is the war on the floor. On my phone, I'm a Starbucks fan, right? I drink Starbucks, they give me rewards, and for me to get on my app, I have to give you my fingerprint to do that.
Yeah.
And I think what I'm hearing you say is, Chris, by the time you press that button and create an act, you're saying that this law says, well, because you did that, there's something in the law that says, well, you can't get loyalty programs because you're probably not offering them.
Well, this is a possible innovation. Right now you stand in long lines at stores sometimes, and everyone has to take out their phone, find the thing, either show their face, put their fingerprint on, figure out what they're going to scan it. Well, there is collection going on there to get your card, whether it's through your iPhone scanning your face or your fingerprint. You can skip all that stuff if you could just, put your fingerprint down. So that it's not like it's not being collected now. We're trying to find ways to make it more innovative, more convenient for consumers, and that they could get through those lines faster, or like the other story you're talking about, not have lines.
So it's basically, just to end this, and I thank you, the point I'm making is that innovation can come in many forms, some of which us as consumers are going to demand because our behavior requires it, and you have to respond to it. And that, I think that's your testimony and why we had a debate on the floor last year on this bill.
And importantly,
that's okay.
And importantly, in the DMV,
He's not posing a question. That's why.
Oh, sorry.
He doesn't want to get in any more trouble.
Okay.
Thank you.
That's a very simple question. Because I've been listening to back and forth, and why y'all are against this bill. Is there a timeline on here? Is this forever that you are opposing it?
I think it depends on the bill. I'm pretty sure most frameworks have restrictions on retention, so how long you can retain the data. It's usually related to continuing to provide the transaction or the benefit or the service that the consumer wants. And so I'd have to go back and to check these bills, but a modern bill, a bill that follows, let's say, the Connecticut framework that's been talked about, that's in 4 other states, has those rules on what's a reasonable amount of time to maintain the data. So I definitely would support including similar language here.
Thank you. Seeing no further questions, I believe that's all for this panel. We have 2 virtual witnesses. All right, put them up. Kara Bender.
Hi, yes, can you hear me?
I sure can, ma'am. Please go ahead.
Great, thank you. Thank you, Chair Wilson, Vice Chair, members of the House Economic Matters Committee. My name is Kara Bunder. I'm State Policy Director at the Computer Communications Industry Association. CCIA is an international not-for-profit trade association representing small, medium, and large communications and technology firms. I want to preface this with saying that we do support the enactment of comprehensive federal privacy legislation to promote a trustworthy information ecosystem characterized by clear and consistent consumer privacy rights and responsibilities for those organizations that collect and process data. But we do appreciate, in the absence of such federal privacy protections, that state lawmakers have an invested interest in filling those gaps in both comprehensive consumer data privacy form and for the biometric data privacy concerns that are addressed in HB 33. In the interest of time, I'm going to condense my comments for both bills, which we are respectfully opposing today. Echoing some of the concerns that were shared earlier, we would encourage lawmakers to consider definitions that are clear and interoperable. We'd recommend that these align with existing definitions and rights that are included in other state privacy laws to avoid unnecessary costs to Maryland businesses. Because even minor statutory divergences between frameworks can create significant burdens for covered organizations. We further detail those issues in our submitted comments. Would also like to talk about the need for time for covered entities to understand and comply with newly established requirements. The recently enacted privacy laws in California, Colorado, and Virginia included 2-year delays in enforcement, and therefore we recommend amending the current effective date to a later date to allow covered entities to come into compliance. And another issue that's been detailed at length today with regard to the private right of action, we would recommend investing enforcement authority with the state attorney general and also including a cure period. That notice allows consumers to receive injunctive relief, but without the time and expense of bringing a formal suit. And business would also be better equipped with time and resources to address potential privacy changes. Thank you for the chance to speak today. I welcome the opportunity to answer any questions.
Thank you very much, ma'am. Seeing no questions, we'll move on to our next witness on this, and I believe final witness on this bill, Margaret Durkin.
Hi, good afternoon, Chair Wilson and members of the committee. My name is Margaret Durkin, and I serve as TechNet's Mid-Atlantic Executive Director. TechNet is a technology trade association representing over 5 million employees in the data security, IT, and e-commerce spaces. Thank you for the opportunity to speak today on House Bills 33 and 807. Regarding HB 33 on biometrics, TechNet recognizes the importance of keeping consumers' data safe. However, there are a couple issues with the biometrics provision specific to data access and then the issue of the authenticated user, which was previously brought up. We're concerned that anyone could say that they're a person who needs biometric data, and really that could lead to a lot of fraud. On the omnibus privacy issue, HB 807, again, TechNet supports the premise of keeping consumers' data safe, and we would encourage the frameworks within the bill that reflect the Connecticut model, as that provides a lot of consumers the ability to port their data as well as provide for opt-in and opt-outs. We too look forward to working with the committee on these important issues. Another aspect of both bills that we're opposed to is, of course, that private right of action. In Illinois, as we heard from other speakers, the BIPA law has led to a lot of frivolous lawsuits, numbering in the several hundreds, and really only one of them has gone to court. So again, thank you for your time on these two issues, and I'm happy to take any questions. Thank you.
Thank you very much, ma'am. Seeing no questions, thank you very much. And I believe that concludes both of those hearings. We will now be hearing House Bill 775. I believe we have our Attorney General, whose name has been used quite a bit today already. So everybody wants you to do a lot more work, apparently. And you do have a panel. I believe the panel I was just told about was Shelley Martin, Steve Sakamoto Wengo, and if you have somebody else in your panel, but was that it? That's it. That's it. Okay. Go ahead, sir.
Mr. Chairman, members of the committee, what an honor to be back. I got my start in the Economic Matters Committee. I was sitting where Colonel Rogers is sitting today, and Mike Bush was sitting where you're sitting, Mr. Chairman. Sonny Minnick was over here where Seth Howard was, and it's been a long time. Yeah. Well, I used to wear facial hair to show my age. Now I just have to share a few stories. But look, it's great to be back. It really is. And as you mentioned, I am joined by two extraordinary members of the Consumer Protection Division. Shelley Martin is going to share with you after my testimony sort of the experience on anti-price gouging or the price gouging work that we did during the pandemic. And of course, Steve is here to answer the questions that I can't answer. But it's great, Mr. Chairman and Vice Chairman Crosby and distinguished members of the Economic Matters Committee. Again, it's great to be here, not only testifying in support of House Bill 775, but sponsoring this bill. Let me just start by saying that nothing that you do is easy. This is an easy one, only because I say that, because you've already done it. Okay, March of 2020. For those of you who are here, you remember, you're on the way out the door because of the pandemic. You had some important things you needed to do to make sure you could protect consumers. And the only time we come to you as a Consumer Protection Division is when we hear from your constituents, our constituents, Maryland consumers. That's when we act. That's when we bring enforcement actions. That's when we bring proposed legislation. So go back to March 2020. You're on the way out the door saying, what do we need to do to make sure we protect consumers during this pandemic? You had the foresight to do that. And you passed legislation nearly identical to the one that you have in front of you. The big difference is that in March of 2020, the legislation put to the governor the authority to pass an executive order, which he did. And the executive order has now since expired. Imagine, if you will, an emergency, a state of emergency, when you're not in session. And many people will raise questions about whether or not the governor has the authority to issue that kind of executive order without legislative authority. I'm not taking that position now. I represent both the General Assembly and the governor. I may have to defend that action one day. I don't want to have to defend that action. That's why I'm here today with House Bill 775. This is not a partisan bill. This is a bipartisan bill. Again, go back to 2020. Governor Hogan supported the bill. Look at 30 states in the District of Columbia that have it, including Pennsylvania, Virginia, and West Virginia, all of our surrounding states. When our Consumer Protection Division receives complaints about price gouging, it often happens in really dire situations like the pandemic, like perceived crises or shortages. And the division received over 1,000 complaints since the start of the pandemic. They've dropped off significantly post-pandemic. Again, highlighting why this is sort of a state of the emergency pandemic type authority that we're asking you to grant to us. In that authority that you gave the governor to issue the executive order and found in this bill, we set up an informal process to address complaints. And frankly, during the pandemic, most of the complaints that were made were resolved during this informal process, where we engaged the retailer, said, hey, look, there's a complaint about price gouging, prices have gone up. They provided information, and the majority of the complaints proceeded without the need for an enforcement action. House Bill 775 provides a similar process, giving the retailer the opportunity to present evidence to the division that a price increase was justified. House Bill 775 only applies during a state of emergency. It would prohibit any business, not just retailers, from raising their prices for what are considered essential goods and services outlined in the bill by more than 10% above what they charged immediately before the state of the emergency. Now, the business can come in and say, look, we're going above 10%, and here's the reason why. Okay? It allows a business to raise its prices by more than 10% if, in the wake of an emergency, the business itself saw increased costs in delivering those goods and services to market. So let me just conclude by saying that Maryland consumers, they deserve the protection against price gouging during a state of emergency. And it's what is enjoyed by consumers currently in over 30 states in the District of Columbia. And with that, Mr. Chairman, members of the committee, I thank you for this time, and I ask for a favorable report on House Bill 775.
Yes, good afternoon. Thank you, Mr. Chairman and members of the committee. As the Attorney General said, my name is Shelley Martin, and I coordinated much of our price gouging enforcement during the pandemic. What we did, we received close to 1,000 complaints from consumers about potential price gouging. So in order to get through those expeditiously and not unnecessarily burden businesses, we established an informal resolution process where a letter was sent to those businesses informing them of the allegation and offering them the opportunity to provide evidence that they either hadn't raised prices or that if they had, it was in response to an increase that they themselves had experienced and were just passing along. And most of the complaints were able to be resolved through that informal process. And of those that were not able to be resolved, we then reached out to the businesses again if we felt that there was a potential for actual price gouging happening, and again gave them a chance informally to produce evidence to show that they hadn't raised the prices or that the price increase was justifiable. And as a result, almost all of the complaints were resolved without the need for any further enforcement action or subpoenas. What we found in the process of resolving those complaints is that price gouging was happening, but most of it was happening further back in the supply chain. It was not the end retailer who was doing the price gouging. They were simply passing along outrageous price increases that they themselves had to pay to get these supplies into the stores. And the emergency legislation did not allow us to go after those, downstream supply chain businesses. But House Bill 775 does allow us to go back in through the supply chain to wholesalers or distributors who may be causing the price increases. And if you have any questions, I'm happy to address them.
And again, just for clarification, even the wholesalers and the people, the other companies that deal with out-of-state and deal in the out-of-state marketplace, they too will have a chance to explain themselves. Indeed, like you said, if it's coming out of state but it's more expensive, then they will also have an opportunity to explain themselves as well, correct?
Yes, they would.
Thank you. Steve, you want to go ahead?
Thank you, Mr. Chairman. I'm just here to answer any questions.
Well, we're always happy to abuse you, so let's see what we have. And Steve has been awesome for years in taking that abuse. So, Delegate Queen?
Actually, I think Seth was first.
Matter.
Oh, okay.
Just playing, Seth.
I tried. Thank you, Mr. Chair. Thank you for this bill. We kind of heard it before, so I do want to get some clarification about what was different before. So I think after the COVID, when we tried to make the emergency, governor's emergency guidance permanent, the issue we had after we got some of the language done, we didn't have much of an issue with the products, but it was around the nurses that were being paid more and because of the labor related to that, and we could never settle on that. Does this bill talk to this at all? And that was a special incident. But
Right, we did not include that particular language in this year's bill. We decided that if the nurses in the hospitals wanted to get a separate bill to deal with that, They could.
So this is mostly products and services, non-labor with dealing with the medical profession?
Correct.
Okay, thank you very much.
Delegate Howard.
Oh, thank you. No, just very quickly, how long did the process take? The one that you spoke to, Shelley, how long did that?
It really depended on the retailer and how long it took them to get back to us. The letters can go out, the initial letters from us, depending on how backed up any of our folks are, pretty much immediately or within a week or two of getting that complaint. I don't want to say that they all went out that quickly because obviously it was a very disruptive time.
Sure.
But usually those go out fairly quickly. And then as soon as the retailer gets back to us, someone can look at that. Now, some of the retailers, we had trouble getting a hold of someone or at least someone with responsibility. So to the extent there were delays, they were usually just us trying to make sure someone in authority at that retailer knew that we were asking and could get us the information.
And this isn't like a cease and desist. This is just a, hey, we've got this complaint, we'd like to address it. So they're still able to operate under the auspices of that they're not price gouging from the outset.
Yes, that's correct. It's just a letter that says, hey, we got this complaint. Do you have any information you want to provide? And then we take it from there.
Okay, thank you very much.
Delegate Chi.
Thank you, Mr. Chair. It's great to see you, Mr. Attorney General. And first of all, thank you for focusing on this very important issue because our office got some complaints from our constituent about particularly gas price gouging. So I know this bill deals with emergency situation, right? But on an ongoing basis, as a legislator, I just like to know how we define price gouging and how to better respond to our constituents when they have complaints, because I know from my understanding, there's nothing on the books right now to specifically deal with that or to even effectively investigate, what counts as price gouging. So that's frustrating to me. I hope we do something as a state.
So just quickly, in the bill, it's defined as a price increase of more than 10% in a particular window. But to your question about this authority outside of state of emergency, we chose to focus on the state of emergency because based on the sort of the history in the office, not just the pandemic, you can go back to other scenarios where it's not necessarily even a declaration of state of emergency, but people are, remember Snowmageddon and all that stuff. You often will see during those periods of time, you'll see increased spikes in prices, some of them warranted, some of them not. But this bill chose to focus on states of emergency.
Senior, a fast one on this bill. Not everything we did back then made a lot of sense. Wasn't perfect. Is there anything you can highlight that isn't in this bill that we did that you took out of maybe this bill from what we learned when we did put this into effect back during the pandemic?
Good question.
I don't have a specific.
Yeah, actually, we added, we didn't take out, and I would disagree with you respectfully. What you did during the pandemic was perfect. Or as John Ledge would say, a perfect imperfection.
Well, I appreciate hearing that from you.
Yeah, but no, so we've actually added a little bit, and as I think Shirley mentioned, as Shelley mentioned, I apologize, the business piece so that we can go upstream to wholesalers if warranted.
Like I said, I just worry because we did react quickly. It was a very tough time, and I just want to make sure everything, without digging into detail, that we got everything covered on this. It sounds like we did. Thank you.
Surprisingly good question, Steve. Thank you very much. You're awesome. We have one more question, Cherie Sample Hughes.
Thank you, Mr. Chair, and thank you. Good to see you, Attorney General. With regards to the up and down the wholesaler piece where you'll be able to intervene in that capacity, and I know you also included in which areas you can cover, such as the communications and internet services. So how long arm is your reach? How far is your reach to be able to work with these providers outside of the state? And does that require you to interface with these other Attorney General offices to secure the information that you need to secure? I was just trying to understand it logistically.
So logistically, that is not the easiest question to answer. The case law is still evolving a little bit, especially with respect to internet-based retailers in terms of which states have jurisdiction over them and where they are doing business. But generally, a company has to have what's called minimum contacts with Maryland in order to be subject to our jurisdiction. So if it was just, someone on the internet who sold one thing in Maryland that one time, we probably would not be able to go after them. But if you're talking about a big company that is regularly doing business here, they're choosing to subject themselves to our laws and would need to answer, our Attorney General's office if we sent them a subpoena or a request for information.
Thank you very much. Thank you, Mr. Chair.
Delegate Rogers.
Mr. Chair, General Brown, just want to let you know that the facial hair was actually very helpful to me. Now people don't come up to me and say, "Aren't you the other guy?" But I appreciate that.
Thank you, Delegate. Well, I believe that is all the questions for this panel. Thank you very much.
Thank you, Mr. Chairman. Thank you, members of the committee.
All right, next we have Franz Schneiderman and Marceline White.
Good afternoon, Vice Chair Crosby, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of Economic Action Maryland. Economic Action Maryland works on economic rights, equity, and housing justice through research, education, and direct service. We're here today in strong support of House Bill 775 and want to thank A.G. Brown for bringing the bill. The bill, as written, is narrowly scoped. It would bring Maryland in line with 31 other states in the country who have these kinds of rules and regulations. And I want to take a minute to tell you why it's needed. As I mentioned, we have direct service programs. We work with older adults providing tax credits, financial counseling and coaching, earned benefits checkups. We run a tenant hotline hearing from tenants all over the state about their needs and providing advice and assistance to tenants. And we run a fair housing hotline. During the pandemic, we received more than 1,000 calls from older adults and from tenants and people calling in about fair housing complaints. A large number of these at that time were around price gouging or around their financial struggles with high prices for hand sanitizer, PPE, and even basic goods and services being part of the financial struggle they were having, because so many of them at the time were experiencing furloughs, layoffs, or juggling multiple jobs at the same time as an essential worker. So this bill is needed. It will address, in limited circumstances and extreme circumstances, the protections people need to not pay outrageous prices at a time of high stress and emergency otherwise. And we think the guardrails are good, it's balanced, the needs between businesses and consumers. And for these reasons, we urge a favorable report. Thank you.
Thank you, Marceline. Thank you, Vice Chair Crosby, members of the committee, for the opportunity to address the bill. My name's Franz Schneiderman. I work with Consumer Auto Maryland, which works for safety and fairness and transparency for Maryland drivers and Maryland consumers. We're in strong support of the bill because it does provide the Attorney General's office with some important powers that protect Maryland consumers against price gouging in these kind of emergency system situations, as we saw with the COVID pandemic, and as frankly I think we've seen in earlier situations where there have been natural disasters. I can remember after Superstorm Sandy in 2012, after Hurricane Katrina in 2005, when there were issues with refining capacity, there were tremendous spikes in prices in those cases, as well as what we saw during the pandemic. So, it's a recurring issue. The power that the Attorney General's office had during the pandemic was important to protecting Maryland consumers. And it's a power that many other Attorney Generals have, and we really ought to have in Maryland. As Marceline indicated, I think it's a fair and balanced way to approach this. It applies to a set of key commodities. It allows price hikes of less than 10%. And if there's issues where the labor shortages or other shortages caused by the disaster require, justify larger price hikes, then those are allowed under this statute as well. So we think it's fair and balanced and an important protection for consumers. Hope you'll give it a favorable report. Thank you.
Thank you. Seeing no questions, we'll now go to the unfavorable. I have Kirk McCauley, Mike O'Halloran, and Kaylee Locklear. And start whenever ready.
Good afternoon, Mr. Vice Chairman, members of the House Economic Matters Committee. For the record, my name is Mike O'Halloran, here today representing MAPTA, which is the Association for Energy Marketers and Convenience Stores. And we are in respectful opposition to House Bill 775. And I do want to just draw your attention to the bill itself, because there are some issues. With the utmost respect for the sponsor, the Attorney General, this does reach back a lot more than immediately before a state of emergency. We're talking about 60 days. Particularly in the motor fueling industry, I'm sure you all are aware that prices do fluctuate well beyond the control of those, to use industry terms, below the rack, meaning those that are driving the tankers to your gas stations and the gas stations themselves. Again, things that are well out of their control. So that kind of leads me to my point of why are we codifying in statute what constitutes an essential good? I would say and argue that should be left to the discretion of the governor based on what that state of emergency is. I don't think any of us in this room could have imagined 3 or 4 years ago the state of emergency that we had to deal with, which is COVID. So who knows what the next state of emergency will bring. And I close by bringing you back to March 1st, 2017. The state of emergency was declared. And that state of emergency was to deal with the opioid epidemic. And I have to ask the committee members, I hope you will consider why a state of emergency dealing with the opioid epidemic would involve food, fuel, water and ice, cleaning products. I think that capitalizes my point about allowing the governor the discretion to pick what constitutes an essential good or service during a declared state of emergency. Thank you.
Good afternoon, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Association in respectful opposition. And I'd just like the record to show that we in no way as an organization support or condone price gouging. The last 3 years have shown us, and it's been acknowledged today multiple times, that when we experience an extended disaster or state of emergency, there are often many outside forces impacting pricing, especially at the retail level. During COVID and similar to other states, the Attorney General's office received thousands of complaints, but not surprisingly, most were found to be unsupported, as production of goods, seasonal changes, weather events, illness, demand, inflation, and other supply chain factors influence supply. Prices vary. As an example, and particularly in the food retail space, a weather event that occurs a year before can drastically impact harvest, decreasing the goods availability and driving up costs with supply remaining the same. And the bill arbitrarily states that a business cannot increase a price above 10% of what an item costs 10 days before 60 days before a declaration, and then 4 days before the state of emergency. And then they would have to prove for every complaint the supply chain costs increased or the labor and materials used increased, even though they do not manufacture or grow the good. The burden of proof in this bill is honestly what's off, because in other states, the burden of proof is on the Attorney General's office. And finally, I just add, Mike already said it, the governor, when issuing a state of emergency, may, and Governor Hogan did this during COVID, prohibit price gouging. So with those comments, we urge an unfavorable report. Thank you.
Vice Chair, members of the committee, my name is Kirk McCauley, and I represent WMDA as service stations, convenience stores, and repair facilities in the state of Maryland. And I'll just echo what Mike said on the items that are listed that would come under essential services. We think those items ought to be declared by the governor, and he should take ownership of it according to whatever emergency it is. Mike quoted the opioid in 2017. None of these would have been needed. If we had a weather event that was going to be forecast as a monster storm and we declared a state of emergency, and it turned out to be not that weathermen here get it wrong sometimes, but they do, and that state of emergency would put into effect automatically. 90 days for some services couldn't be used. So even if it was declared off a week later, if it was declared non-thing. So just odds and ends. We have no problem with the bill. It's just with some of the content of it. And one thing that does bother us a little bit, under the governor's bill last time, there was no wholesale involved in it. I represent retail, so I'm not taking up for no wholesaler. But, but the wholesalers are the one we get our supply from. And if the out-of-state wholesalers are worried about being charged by an attorney general for shipping supplies in, that it would be pretty complicated for them to prove, they just might not do it. It happened in 2012 when Sandy come up. New York Harbor was all busted up. Refineries up there were down. Phillips 66 was down, biggest refinery on the East Coast, and some of the New Jersey refineries down. Delaware wouldn't haul fuel into there. They had to take an order from the governors to get the fuel ordered into there because they were afraid of price gouging laws that New York had. And New York laws are pretty good. But thank you, and we're not opposed to the bill if some of them things were fixed. Thank you.
Question, Mike, just real quick. In the 31 other states that have enacted this, right? Like, I understand the concern, but what did they do in those states? All right.
I couldn't ask you because I don't have clients or members in those 31 other states.
Okay. All right. We'll look it up. Seeing no other questions, that concludes this bill hearing. And next we will go to House Bill 254, which is Delegate Frazier Hidalgo. I'd like to welcome members from the Ways and Means Committee, Delegates Patterson, Fair, and Hornberger.
Just fell apart. It just fell apart. I'm sorry about that. I just tried to move it and the whole thing kind of disintegrated in my hand, so.
Do you want me to have Delegate Fisher hold it for you?
Yeah. This is my little buddy right here.
Go ahead. You start when ready, Delegate.
Thank you. Thank you, delegates. Thank you, Mr. Chair, Vice Chair, members of the committee. I'm here to introduce House Bill 254 today. I'm going to do this in a slightly unorthodox manner in which I talk about this bill. Because I know a lot of you are probably like, what is this bill about? So approximately 92% of U.S. teens are active on social media, and data has shown that minors typically start using social media at around 11 years old. Teens who spend a great deal of social media, over 3 hours a day, social media often report symptoms of loneliness, depression, and anxiety. By the time a child turns 13, it has been estimated that advertisers already hold over 72 million pieces of data on that child. More than 2/3, that's over 1,000, of the most popular iPhone apps likely to be used by minors collect and send their personal information to the advertising industry. A recent study found that nearly 90% of education apps and websites send information to the tech industry. So I tell you all this because this is all about money. This is all about advertising. This is all about like building profiles for our kids, setting them up when they're 10 years old or 12 years old or 15 years old, setting them up, building their profile so that advertisers can sell to them and make money off of them. All our children are to these social media companies and to tech are really dollar signs. That's what they are. I'm sure many of you just saw in the news 2 weeks ago a 14-year-old girl that was bullied and beaten publicly in her school, videotaped. It was videoed, and then it was put up on social media, and 2 days later she committed suicide. A year and a half ago, my children in their school witnessed 9 physical fights. With those 9 physical fights, that's just the ones that they witnessed. Later came the 3 Instagram channels that I found at their school, and on those 3 Instagram channels, 3 completely different people, kids, posted fight clubs with kids that knew each other, beating each other silly, beating each other in classrooms and particularly in hallways in Montgomery County Public Schools. That was the 3 Instagram channels, and then I found 1 YouTube channel. And they all got pulled down, but it took time and damage was done. Now, the reason that this bill is here today is because the feds aren't doing anything about it. I don't want to have this bill, House Bill 254, that deals with social media giants. I don't want to have this bill here. You don't want to have this bill here. I wish the feds would do something about it. But for the last 10 or 12 years, the feds have done absolutely nothing about it. And our kids are getting marketed to, they're putting dollar signs on them, and then because they're young, they're getting marketed to, and in some cases, they're committing suicide. So Tristan Engels, which is a licensed forensic psychologist, said that when it's circulated uncontrolled in unregulated environments like social media, it opens up victims and families and teachers and communities to more forms of cyberbullying. People of online, Engels said, which means that they say cruel and harmful things on social media with a degree of anonymity, which sadly was something that in this particular case, this girl felt, and she was being subject to both school and online bullying. Experts say forums like Twitter, Instagram, TikTok are especially attractive to adolescents who look at their peers for cues about what's cool, crave positive reinforcement from their friends, and are more prone to risk-taking behaviors, particularly when they know that they're being observed by those who will approve their behavior. So what does House Bill 254 do? House Bill 254, I'm sorry. It says that if you're between the ages of 14 and 17 years old, that you have to get authorization from a parent to have a social media account. It says if you're below the age of 13 years old, you cannot have a social media account. It says that the social media industry, if they allow that to happen, that they will get fined. If they do not pull down an account of a minor, within 24 hours, they will be fined. It also says it establishes a citizenship literacy fund for digital literacy, and what it says is that the social media, if they violate these provisions, they have to pay into that, and that's used to help educate kids. It also says that they have to provide a report to the AG's office twice a year, and in that report, they have to stipulate which accounts they brought down. If they fail to do so, they'll be fined as well. And just for the record, because it's social media and they're very, very big, the fine for them is $100,000 for not pulling it down, and $5 million if they don't submit their report to the AG's office. Now, I know that there is another bill that I think that the chair and some others are working on that's similar. I was not aware that there was another bill. This bill is a rather blunt instrument, and it's a rather blunt instrument because I will tell you that I am really, really sick and tired of the social media giants basically making excuses why they cannot police their content. It is their platform. It is their platform, and they should police their platform and not put their profits above our kids. And that's exactly what they are not doing. So I'm happy to answer questions. I'm happy to talk more about the bill. Again, I wish I didn't have this bill before this committee. I wish the feds would do something about it, but that's where we are.
Delegate Jackson.
Thank you, Mr. Chair. Thank you for the bill, Delegate. My question is, how exactly would a platform verify that the account has been authorized by a parent, or what would that look like?
That's a great question, and I would submit to you that you ask them. That's not my problem. They need to do it. They need to stop telling us, they need to stop giving us excuses about why they can't do things, and they need to start doing them. I am sure there are ways for them to do it. They can be creative. They get paid billions of dollars a year to do this, so I'm sure they can come up with a solution. Thank you.
Delia Weil, did you have a question? You get scared? Okay, all right. Okay, seeing no other questions, thank you, delegate. Next, we will turn to the unfavorable. Zachary Lilly, Margaret Durkin, Jordan Rodell.
Do you all want me to leave this here so everybody can see this during your testimony?
I haven't seen it yet, but probably not.
It is. In case anybody's wondering here.
Mark, go up there and hold that? No. I don't know. Are you the only one here, sir?
I think I'm the only one in person. So
Oh, you are right. I apologize. The others are virtual. I got you.
So I guess I will start. My name is Zachary Lilly, and I'm the Deputy Director of State and Federal Affairs at NetChoice. NetChoice is a trade association of large, medium, and small American tech companies. I'm here today to ask you not to advance HB 254. I would prefer to start with the positives because there are positives I find in the bill. I'm glad to see the bill recognizes the importance of educating young people in the safe use of social media and the internet. It is a good example of the ways in which the state can act in good faith to protect adolescents while preventing the government becoming the third parent in every Marylander's family. The problem, however, begins as soon as the Maryland legislature starts taking unconstitutional cues from states like Florida, California, and Texas. Following similar legislation which NetChoice has challenged, states have declared their citizens unable to effectively parent their own children in direct violation of basic principles of privacy and anonymity online. HB 254 would require a massive expansion of data collection by private companies and the state government. While the target of the legislation are Maryland minors, the only way to meaningfully differentiate between users is to verify the age and personal information of each individual user in order to protect a covered entity from liability. There is no question that such a misguided regime of privacy violation will chill free expression online in direct violation of the First Amendment. I also want to highlight the perverse incentive of creating a state agency largely dependent upon collecting fines built upon unconstitutional state data collection efforts. Law enforcement should be impartial. Enforcement officials and apparatuses should not stand to gain financially from their work. The legislature should move to increase and improve the multi-stakeholder approach to children's safety online. Online platforms aren't the enemy, and the most effective methods to keeping kids safe have all been developed and deployed by these same platforms. Maryland should not rush to mow over the First Amendment in a charged attempt to attack America's tech sector. Thank you.
Thank you, Chair. At what age do you deem it appropriate for someone to be on social media?
I would never presume to be in the position to decide that myself. From my perspective, a parent would be the best indicator of their child.
First grade?
Again, I wouldn't proffer a specific.
All right, I'm going to push, not because I necessarily, I got to look at the bill, but I think I'm asking a fairly reasonable question that the bill sponsor is asking, which is at some point, isn't there a conversation about what social media is, the venue that it is, and maybe there would perhaps be some limitations that that this bill is asking put in place. I think I'm asking a question that doesn't cause you to go off on a limb. I'm just saying as a reasonableness conversation, what's that age? I mean, so you're not answering it, and I don't want to be argumentative. I was expecting a little bit something more substantive than that.
Yeah, I mean, I don't process your question as argumentative at all, and I appreciate it. It's just, I do think a reasonable conversation can be had about what that number might be. I just I'm not comfortable putting out that number, but I don't disagree that reasonable minds can differ and then also potentially decide on that number.
That answer I like. Thank you very much.
Thank you, Mr. Vice Chair. Is there a way, I'm going to ask the same kind of question here. Is there a way for a platform to verify that a parent has authorized a minor's account?
I can do some more digging, reach out to particular member companies. I'm just not an expert on every single regime that they individually will use. I believe the answer is yes to a certain degree, but I think to get to the level of specificity that the bill is asking for, it would require additional information to be obtained, particularly potentially private government documents or like a driver's license, et cetera, to prove, right? Because the idea is that you're trying to make sure that unauthorized minors aren't creating an account, which I agree is reasonable. The concern is that in order to say this person is a minor, you have to confirm that for every specific individual person. And if there's an intense degree of liability attached, a social media company would never allow the creation of an account unless they have a sufficient amount of private data on you to make that determination. So you're creating a regime, right, in the interest of privacy, which conversely violates a significant degree of privacy. There was a recent study that came out 2 weeks ago from the Center for Growth and Opportunity out of Utah State University that north of 60% of Americans would oppose transparency requirements if it required them to give over additional private information like a driver's license or other such documents, and that number raises to almost 70% when the question becomes about offering up to those companies their children's information. So again, I don't fault the bill sponsor certainly for the goal of the legislation. My concern is by enacting what has been described as a blunt weapon, that we're actually making a lot of other problems significantly worse.
Thank you.
Thank you, Mr. Vice Chair, and thank you for allowing us to visit over from Ways and Means. We do hear a number of these bills. They more so tie into bullying in schools, massive issue. You know, as a father, I've had to deal with these issues as well. I don't think that anyone in this committee, and I can't speak for the sponsor, believes that they're going to solve this problem by passage of this bill, right? Like, we just need to start somewhere. So my question to you is, if I go on one of the sites that I like, whether it's a cigar site or maybe it's an alcoholic beverage site, each time I visit that site, I have to affirm that I am of a certain age. And then generally there's a follow-on question that says, you know, what's your date of birth, or some sort of measure there that adds another level of security. Why is that not able to take place on a platform that is thousands of times more lucrative than these sites that I'm visiting, which in many cases are run by a single individual? Why is it that they can have that level of technology and roadblock there for someone who's not of a certain age, because they've self-identified that there's a material on there that isn't suitable for children? Why can't the cohort that you represent at least start in earnest to do something similar to that?
Yeah, I would posit that if the legislation were written in such a way where it was specifically asking for that level of technology, right? The language is fairly general. Again, earlier testimony specifically laid that out, that it wasn't the problem of the sponsor, it was the problem of the companies, right? And so if, not that I would be in a nicer suit if I was, but if I owned a major tech company and my bottom line depended on making sure that the Maryland legislature, the Attorney General's office, et cetera, felt good about the level of information that I was collecting in order to make sure this person is a child, is not a child, I would collect as much data as humanly possible. It wouldn't simply be an affirmation, as you suggest in similar sites, right? So we might be able to have that conversation, right, if it was written more specifically into the law of what is reasonable versus what is sort of strictly punitive. Again, like with other folks who have raised concerns, you know, I'm not like, yeah, as someone who self-identifies as recently young, I used my childhood is marked both by a time when social media didn't really exist and by a time where social media was integral. So I'm very familiar with both the challenges that social media creates and the benefits that it offers. So again, to the credit of the bill sponsor, the first section, which creates that attempt to educate young people on how to safely and effectively use these online technologies, I think is incredibly important.
Okay, thank you.
Thank you, Mr. Chair. I appreciate it. And thank you, Mr. Lilly, for your testimony today. I wanted to follow up. Have you created a Facebook profile in your lifetime?
Yes, I think it was in 2009. So if you're going to ask me the specifics of what they asked me when I made it, I, in good faith, do not remember.
That is perfectly fair. I'm sure you would be surprised to find out that I just decided to create one.
Oh, well, welcome.
So,
Please add me.
would you, I'm curious, would you be surprised to find out that after it asks you if you would like to upload all of your contacts as the first question, if you'd like to give access to all of your photos as the second question, and after the third question of asking your name, that the fourth question asks, what's your birthday, with no option to opt out of that question? Would that surprise you to know that Facebook collects this data regardless?
No.
Okay. Additional collection information that they put on there includes your gender and other geographic data that they claim you can make private. However, do you believe that Facebook stores that data?
I'm not sure about their particular data practices.
Okay. So, but they do ask the questions. Would you say it's safe to assume that those questions are asked and they're not just thrown away?
Well, I mean, I know I have my birthday on there so that I don't sit in my apartment alone without having someone wish me a happy birthday.
Very fair. As soon as we're friends, I'll be the first one to wish you happy birthday.
Thank you. It's coming up.
Absolutely. So I guess my question is, Facebook has these questions already built into the pie, and they give the option of making even the answers private. However, I think that it's, in my estimation, impossible for them to ask the question, for you to make an answer, and for them not to actually collect that information. So when we say that that this information is being collected or should not be collected or be available because we're in violation of privacy issues, is it technically the data is already there? We're just simply stating that Facebook or others, I'm sorry, I shouldn't use names of individual, but all social media platforms collect this data to start with. So we're just asking them to implement that data collection to hold, to make sure that the delegates' intent of this bill is honored.
Again, if that level of specificity is written into the legislation, if that is specifically what the law is asking to be collected, but through my reading, that isn't necessarily what any particular tech company could rest its laurels on. It would have to guess at what would be deemed sufficient in order to confirm the age and identity of each user. So again, goal not to be obstinate here, it is just to say that that level of specificity, I think we could have a reasonable debate on where the line exists. But currently, as currently drafted, there is no line.
I really appreciate it. Thank you.
Yeah, thank you.
Delegate Aarons.
First of all, I appreciate the intent of the bill, but if I follow the delegate scenario, I know I get on Facebook and I get somebody wants to friend me named Alistair Cook. I don't know who that is. You don't know who that is. They had to get on there. They had to enter this information. I just find it this whole process would be grossly unmanageable because there's so many ways around it that I don't know that. I think that cat's out of the box. Isn't that the old saying? I don't know how. Bag, box, whatever. I box my cats to just want everybody to know that. So, it holds up better. But again, I think we're dealing with something here that we've had this conversation before about what we can put on a menu, and sometimes it comes down to parenting. And I think that's something where I don't know how you do that at this point. This thing is so out of control. The name calling, the the generations are now so into it. I mean, I suspect most of the people in this room might have multiple accounts. They may have Twitter accounts, and I don't know any of the other acronyms because I don't really do them myself. But I appreciate it because there are some serious dangers online. But putting a criteria that I can put my name in there and say, I'm Steve Aarons, my daughter Peggy Sue can't use this. Peggy Sue's going to go get change her name to whatever, and she's going to go get one of her friends the key of that information in, unless you have a physical thing. I think it's unmanageable, but I do appreciate it because I think it's a very serious problem. I would encourage you all to go back and maybe take a look at it. Wouldn't you agree?
Yeah, I think that's correct, and that's why I wanted to go out of my way to stress why I do really like how the bill starts with the focus on education, right? Because I think before employing the blunt object of the second part of the bill, I do think there is a lot to be made from a sustained public education campaign around the tools that exist that tech companies have devised. Right, just as an example off the top of my head, because I was on the app the other day and it came up as an ad from the platform, but TikTok is rolling out linked accounts between the parent and the child, right? I don't know exactly what that will look like, right? But to say that the tech companies are doing nothing, I don't think is accurate. Now, obviously, like I've said, we can all disagree, I think, respectfully on whether or not that's sufficient.
I think our schools have tried this. Our schools have given these kids our kids computers and said that we're going to lock you out of that. You can only sign in to use this, and this. And I've seen some of the results of that when my son brought the computer at home, and I've seen some of the people, how they've been able to find ways around all that. So.
Oh yeah, there's no doubt that the average 10-year-old is probably technologically smarter than everyone in this room.
Then Steve, you could say it, then Steve.
I'm going to miss you.
Yeah. All the names in the world, and you came up with Alistair Cook. All right, final question, Delegate Charkoudian.
I think what I heard you saying is that this, moving forward with this kind of regulation, is the state sort of usurping parental roles or responsibilities. Did I hear you right? Is that?
Yes.
And I guess I wonder if you think that when, if my 14-year-old son, 15-year-old son were to go into a liquor store and following state law, the liquor store could make money from selling him alcohol, instead checks his ID and denies him from purchasing that alcohol, if that is the state usurping my parental responsibility?
No, as it's a controlled substance, I would say it probably exists in a separate category.
Okay, thank you.
Okay, seeing no further questions, we will now go to the virtual unfavorable. We'll go to Margaret Durkin.
Good afternoon, Vice Chair Crosby and members of both committees. My name is Margaret Durkin, and I serve as Executive Director for the Mid-Atlantic at TechNet. TechNet is a technology trade association with over 5 million employers in the data privacy, e-commerce, and IT spaces. Thank you for the opportunity today to speak on House Bill 254 regarding regulating children's social media. TechNet understands the importance of keeping young people safe online, and its members are committed to providing an age-appropriate experience for young people. We also support the idea of digital citizenship education. However, we feel that the approach in House Bill 254 is not the way to fund said curriculum. There are a lot of problems with the bill as drafted, including the account verification. As previous speakers mentioned, platforms have a lot of abilities in terms of regulating who is on there. However, no system is completely 100%, and there's really no way for platforms to decipher between who is over and under the age of 13. In terms of parental access, TechNet and its members believe in the importance of parental controls, but we want to balance them with a teen's privacy. For example, there could be a scenario where a young person might not feel comfortable talking with their parents about some things and have different beliefs that they might want to access on the internet that's separate from their parents. There's also the idea of account removal. Anyone can claim to be a parent removing an account, and we believe that impedes on free speech. And finally, the bill also contains a private right of action, which always leads to frivolous lawsuits, and we believe that the Attorney General should have the exclusive authority. In conclusion, we agree with the idea of protecting children online. However, we would encourage lawmakers to partner with organizations and companies that have protections in place and promote digital citizenship education. Thank you.
Thank you. Jordan Rodell.
Thank you, Vice Chair Crosby and members of the Economic Matters Committee for allowing me the opportunity to speak today. I'm Jordan Rodell, State Policy Manager at the Computer and Communications Industry Association. CCI is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. While we certainly support the implementation of digital citizenship curriculum in schools, there are several concerns we would like to raise for other policies HB 254 would implement. First, the bill includes vague requirements over authentication that create serious compliance risks and confusion for businesses. In order to achieve meaningful children's safety protections, it is imperative for businesses to have a roadmap of how to properly comply. Specifically, it is unclear how organizations are to achieve minimal collection of information about a child, but also must collect sufficient information, including geolocation, to ensure that they do not reside outside of the state when confirming they are an authorized user. It is important to note that the fine per violation does not allow companies the opportunity to course correct and consult with the Attorney General to find a solutions-based approach. We suggest putting in a cure period to allow businesses the chance to come into compliance and help ensure that these events are not likely to occur again. Second, the reporting requirement in this bill is duplicative of efforts already underway. Many online platforms voluntarily and regularly generate transparency reports and publicly make them available on their websites. CCI recommends that the reporting requirement be limited to annually instead of biannually to offset the time and labor necessary to produce such detailed reports. Next, the private right of action would result in the proliferation of frivolous lawsuits. By creating a new private right of action, the measure would open the doors of Maryland's courthouses to plaintiffs advancing frivolous claims with little evidence of actual injury. Lastly, industry efforts to support teen safety and privacy online could be bolstered by curricula focused on how to be a good online citizen. Due to many of the positive impacts social media and online services as a whole have had on connecting with loved ones, education, and much more, it is imperative to educate young people on how to appropriately and effectively navigate these spaces to further facilitate positive online outcomes. Thank you for your time.
Thank you, and this concludes the unfavorable. We'll now go to the one information virtual witness, Dylan Moses. Zach, you're good, man.
It was just.
No, we're done beating you up. We're good. I got you. Thank you. Good job.
Well, good afternoon, Chair and members of the committee. My name is Dylan Moses, and I'm a fellow with the Integrity Institute, an organization focused on the theory and practice of protecting the social internet. I'm also a former employee of a couple of the social media platforms that we've been talking about today. I'm happy to be speaking with you about this bill. Social media is a powerful tool. It delivers products and services at lightning speeds, from the promotions you receive through Google, Instagram's thoughts on the product you might like to buy, and Facebook's suggestions for what new friends you might want to connect with. But these platforms have negative externalities, particularly for children. Time and time again, social media products and services are often implicated at the center of tragic situations like the slew of ultra-hazardous viral challenges, the increased propensity for anxiety and depression, and in some isolated instances, deadly mass shootings. So what's to be done here? The bill provides a step in the right direction, at least for age verification. It ensures that platforms have a bare minimum in terms of ensuring that under 13-year-olds don't have access to a social media account to collect data unnecessarily. It's easily implementable by many of the large platforms. Some are already doing some of the things that are in this bill that you're requiring. Cost shouldn't be an issue, mainly because it's a simple reallocation of a lot of the content moderation resources that these platforms already have. And then there is always the check for transparency reporting that's happening right now. Some things that are missing from the bill, I think, are things like defining the difference between a public and private account. Taking into account the fact that a platform might need to still hold on to data for ongoing investigations, judicial review, and for ongoing improvements to product safety for minors. Some other things that might need to be improved are just thinking about the gamification for some of the joint accounts that some folks have already discussed today. And then also thinking about how to assess the fines for certain platforms. If they're not making $500 million in revenue every year, they only have a million monthly active users, maybe they're not as able to assess or to take on some of those fines. And so those are just some things to consider as well. Thank you very much for the time, and I look forward to answering any of your questions.
Thank you, sir. And seeing no questions, that concludes this hearing. I want to thank our colleagues from Ways and Means for coming over. Next, we will turn to House Bill 795, Delegate Vogel. Delegate Vogel, is Marceline White and John Braille part of your panel? They're favorable.
If they are here, then yes.
Okay. They can come on up. And you can start when ready. Is this your first bill?
It is not.
Okay. Is it? Well, this is your first time in ECM, isn't it?
It's good to be here.
Yeah, you're off the hook. Delegate Fisher isn't in the room. Go ahead.
Well, Mr. Chairman, members of the Economic Matters Committee, for the record, I'm Delegate Joe Vogel testifying in support of House Bill 795. The November 2022 Ticketmaster Taylor Swift ticketing fiasco highlighted the consequences of the monopolization of the ticketing and live event industry. Since the 1990s, Ticketmaster has had almost full dominance of the ticketing industry, and their 2010 merger with Live Nation left them with even greater control of ticket buying consumers, artists, and venues. It is the responsibility of Congress and the federal government to crack down on this monopolization, as this is not in the jurisdiction of this committee or the legislature. However, monopolies lead to harmful consequences for consumers, and it is our responsibility as a legislature to protect the consumer welfare, especially in the face of egregious offenses. This bill is an effort to affirm the rights of ticket buying consumers and expand their protections when purchasing tickets for live events. Ticketmaster's monopoly enables them to engage in deceptive practices. These include unfair restrictions on ticket resale, narrow and confusing refund policies, excessive and opaque junk fees, and deceptive price advertising. This bill restricts ticket sellers from prohibiting consumers to resale and transfer their ticket, requires ticket sellers to provide refunds to consumers in certain circumstances, requires the price of tickets to include all fees and taxes, requires ticket sellers to be transparent with the number of tickets being sold during pre-release and the seat number and row for tickets being sold in large venues. In advance of this hearing, we met with representatives from Ticketmaster and Maryland-based event venues. I listened carefully to their concerns on potential unintended consequences, and as such proposed several amendments to address these issues. We are still waiting on the amendments from bill drafting, but we should have them shortly. These amendments provide exceptions on resale and transferability requirements, remove the cap on ticket resale prices, and exclude small venues with less than 1,000 seats from certain provisions of the bill. This bill, as amended, does not hinder the ability of ticketing platforms or the Office of the Attorney General from cracking down on scalpers or bots. The legislature has previously considered and passed legislation to address these concerns. Rather, our amendments seek to further empower the Office of the Attorney General to enforce these existing laws. Through sponsor amendments, we are also addressing the concerns of small venues. This is ultimately an issue of fairness. Right now, Ticketmaster essentially has unlimited power over ticket buying consumers, venues, and artists. Their practices are intended to maximize profit, even if working Marylanders are forced to pay the price. I urge a favorable review on HB 795.
Good afternoon, Vice Chair Crosby, and members of the committee. My name is John Braille, and I am the Vice President of Public Policy, Telecommunications, and Fraud for the National Consumers League. Founded in 1899, NCL is America's oldest nonprofit consumer advocacy organization. Thank you for giving me the opportunity today to testify in favor of HB 795 on behalf of NCL, the Consumer Federation of America, and Sports Fans Coalition. For more than a decade, our organizations have worked with allies in the public interest community, independent venue owners and promoters, artists, and responsible ticket resale marketplaces to create a fairer live event industry for consumers. Fans in Maryland and throughout the country benefit from an open, competitive marketplace for live event tickets. This year, our organizations created a Ticket Buyer Bill of Rights, a set of principles we believe should inform any pro-consumer ticketing legislation. We are pleased to see that HB 795 reflects many of these principles, including enshrining into law the right to freely transfer tickets, the right to know the full price of a ticket, including fees, upfront, and the right to know how many tickets will be made available. The common sense consumer protections in HB 795 would put Maryland at the forefront nationally of states that have made putting fans' rights ahead of the interests of a monopolistic ticketing industry that is too often rigged against consumers. While we support HB 795 as proposed, we would urge the members of the committee to consider adding additional protections to the bill. Provisions from the Ticket Buyer Bill of Rights we would recommend including are the right to obtain discounted tickets, the right to a marketplace free of ticket bots that resellers use to illegally purchase tickets in bulk, and the right to be protected from deceptive resale websites that are designed to mimic the box office's site. Our organizations stand ready to work with this committee to make a strong bill even stronger with these protections, and we respectfully urge you to favorably report this bill. Thank you.
Good afternoon, Vice Chair Crosby, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of Economic Action Maryland. Economic Action Maryland advances economic rights and equity and housing justice through research, education, direct service, and advocacy. We're here in strong support of House Bill 795. I will not repeat what my colleague and what the delegate have already explained. I will just highlight that given the market dominance of Ticketmaster, they've been able to engage in a number of deceptive practices and add-ons, and we think it's in the good of the consumer and the good of Maryland families that we pass this bill. I've been here and this body has passed a number of bills to increase consumer protections around ticketing, and this is really the next step in that effort that you all have supported in the past. Particularly, I want to say that I think a lot of the actions are anti-competitive. Things like restrictions and prohibitions on reselling a ticket, requirements like requiring a photo ID or the exact credit card to get into a venue, and deceptive ticket prices. A ticket price that looks one way and then when you go through all the add-ons is a very different price are some of the things that this bill would address. We think it's scoped appropriately, and we think it expands transparency and consumer protections. And for these reasons, we urge a favorable report on HB 795.
Delegate Queen.
Thank you, Mr. Chairman. Thank you, Delegate Vogel. Very interesting bill. As was mentioned, we have done some things with ticketing, but a lot of these issues are, we know, national kind of concerns. So my question is more directed to the National Consumer League. What other state has legislation like this?
Thank you for the question, Delegate Queen. New York State recently passed legislation that would mandate things like all-in pricing. They also have transferability protections in their law. Colorado is also another state that has passed laws to protect ticket transferability and include other consumer rights, such as those proposed in this bill. And in fact, I would point out that Colorado's bill has been so effective that Ticketmaster is at this very moment lobbying in favor of a law that would weaken those protections, because they do see it as a way to where they lose control over an industry that they currently dominate.
Okay. And about a time frame these have been in practice?
The New York State law took effect at the beginning of this year. There have been other provisions of it, like the transferability protections that have been in place for a number of years before that. The Colorado bill, I'd have to get back to you on when that took effect.
And you said California too, I thought. No?
I did not mention California, no.
Just
New York and Colorado are really the leading ones.
Okay.
There have been efforts at transferability protections in a number of other states, including Georgia, Connecticut, New Jersey, and others, and I'm happy to get back to you with a full list if you'd like.
Thank you. I'm a diehard Commanders fan, season ticket holder, and you guys are tough on Ticketmaster. I mean, Ticketmaster has been a pretty effective platform for me, both in owning the tickets, but also reselling them through a marketplace that I'm not sure why you're. I mean, let me ask the question. I've made a statement, and you can respond to it if you wish. As a season ticket holder that uses Ticketmaster, how does this bill affect my ability to resell a ticket to the Cowboys game, which is normally a high demand ticket irrespective of my team's record?
Sure. Is that a question for me, Delegate?
Sure.
Okay.
Yeah.
So this bill would protect your rights as a season ticket holder. Right now, if you want to resell your ticket, you have the ability as in here to resell it on StubHub on Ticket Exchange, which is owned by Ticketmaster, or any number of other ticket resale marketplaces. However, absent protections like this, we would expect Ticketmaster, along with their clients like the Commanders, to try and put restrictions on the ability of season ticket holders like yourself to use competing marketplaces. We've seen this in other states where Ticketmaster has worked with teams to try and restrict the ability of season ticket holders to use the exchange or resell the ticket however they like, instead forcing them to use an exchange where only Ticketmaster sets the fees and the terms of the sale. We don't think that's right. We think that competition is best for consumers and fans like yourself.
Okay, so when it says here that a ticket issuer, ticket seller, primary ticket sales platform, and secondary ticket exchange must establish a maximum markup value of $0.
So we have amended. We've amended that to remove that cap.
All right, so you're responding to the issues that people like me might have that relate to, but I'm still a fan of Ticketmaster because it's my place to buy tickets.
Right.
And I think you're softening a strong platform that obviously is doing business to put venues in front of me as a buyer, and their relationship between the venue and them matters little to me.
Mm-hmm.
It gives me a chance if I'm going to Colorado, Denver. I mean, I don't know what game I'd want to watch there, but let's say I'd want to go watch a rock concert at the Red Rocks. I'm assuming that Ticketmaster might be the place that and then I'm buying tickets off and go. It's a trusted platform. It's a reliable platform. And yes, you pay a premium to do it, but I promise you one thing, if you do it through that, since we're calling out a company by name, I'm pretty much assured that I can walk away after making a purchase to go to Red Rocks and listen to a band play, that I'll be able to get into the venue. So that's what you get from them. And I'm just curious why we're so tough on Ticketmaster. They're here to they're a for-profit company. They're going to make a profit. That's my question.
Well, the reality is that they dominate the market right now, right? So since the 1990s, they've taken up 70, 80, if not more % of the ticketing market. And you mentioned a premium. The reason you're paying a premium is because there's no competition in the industry, right? You can only buy, in most cases, you can only buy tickets from Ticketmaster. So you'll find written testimony in your floor system that points to the fact that tickets have gone up in price 82%. Over the last few decades, and that's because when you only have one source for buying tickets, they're able to charge the fees that they want to charge.
Well, I mean, there's SeatGeek, and I just found this as a season ticket holder, I'm going to have to use that platform this year, not Ticketmaster. So I would argue that there are competitors, and the question is, are they trusted competitors? Are they competitors I'm willing to make I mean, these are expensive, I'll grant you. I was in Buffalo and Detroit this past fall to go to football games. Those were bought on Ticketmaster. I didn't want to mess around. I mean, those were expensive tickets for 5 of us to go hang out. I'm being argumentative. I think you've answered the question. You're saying that Ticketmaster is dominant, and I'm saying as a consumer, there's probably a reason. Thank you very much.
Well, if I can just respond quickly to that, you mentioned secondary markets, SeatGeek. And this is outside the scope of this specific legislation, but there have been reports of practices that Ticketmaster has participated in recently, where they actually direct some of their tickets directly to the secondary sale market to actually drive up prices. So it's part of a deceptive pattern of practices that Ticketmaster has been engaging in with one very clear interest in mind, which is to drive up corporate profits while really making working families pay the price.
Okay, so seeing no further questions, we'll go to the only virtual in favor, and that's Ashley Hogland.
Hi, yes. Good afternoon, Mr. Chairman and members of the committee. My name is Ashley Hoagland. I'm the Chief Operating Officer of Encore Tickets, which is a Maryland-based ticket resale business that has many employees, pays Maryland taxes, and has been in business for decades. We were one of the founding members of the NATB and helped to create the strict Code of Ethics and Consumer Protection measures. I'm personally a member of the NATB's Women's Initiative, and most importantly, I'm a fan. I grew up on Utah Street, and I grew up on the lawn at Meriwether Post Pavilion, and a lot of those experiences were made possible because of the ability to easily access and buy tickets at affordable prices. As consumers, we're actively participating in open competitive markets every day, from fashion to automobile to kitchen appliances. Many of us have benefited from resale and the use of secondary marketplaces. When a healthy secondary market exists, consumers are presented with opportunities to purchase items that may not have been available to them when they initially went on sale or in their local marketplaces, as well as lower prices. And the economy benefits because we are each using our own wealth to generate more wealth that will later be used to create more wealth. So discussions surrounding the fair and open ticketing market are often overshadowed with terminology that evokes negative emotion and distracts the public from the greater social benefits that actually are created when a healthy secondary market exists. And I believe that the right to transparency and transferability play a major role in the health of this competitive market, which is why I'm here in support of House Bill 795. A great example of this is Amazon and their vibrant resale market. 58% of Amazon's sales are credited to third-party sellers. Third-party sellers are defined as business entities or individuals that provide access to markets, products, or services that are in high demand. Amazon's third-party sellers use a variety of different methods to earn money, including retail arbitrage, wholesale models, and nearly 26% of these sellers choose to purchase items directly from a brand or distributor with excess stock to later resell on
Ma'am,
Amazon.
I'm going to need you to start to wrap up.
Okay. And in 2022, 73% of these sellers reported profit margins above 10%. So despite third-party sellers earning profits from the resale of in-demand items, consumers willingly participate in these open markets because of the convenience freedoms it provides and the fact that the price paid reflects the market value. The original issuer is setting prices, and those prices are paid in full, plus fees and handling fees
All right,
and other
ma'am,
fees.
I'm not trying to cut you off, but we give everybody about 2 minutes, and we're at least
Okay,
a minute over.
last
So
sentence,
no,
last sentence.
I'm gonna stop you. Okay. Thank you so much for
Sounds-
testifying. Seeing no questions, that concludes the favorable panel. We will now go to favorable with amendments. First up, I have Brian Austin, and then on virtual we'll go to Bruce Mars. Is he in the waiting room? Mr. Austin, go ahead and start whenever you're ready.
Good afternoon, Mr. Vice Chair, members of the committee. For the record, Brian Austin, State Circle Strategies, here on behalf of Ticket Network. Ticket Network is a secondary ticket platform that facilitates transactions between event ticket buyers and sellers in the United States and worldwide. You have our written testimony, so I'll be very brief. We are in strong support of this bill as amended. HB 795 brings needed consumer protections to the marketplace, including refund requirements, ticket transferability, and transparency. Regarding transparency, I would like to draw your attention to page 5 of the bill, lines 23 through 26. This section reflects what is known in the industry as all-in pricing, where ticket pricing and fees are known to buyers before personal information is given on the platform. As mentioned earlier, these provisions are currently being in place as a policy in New York and Connecticut and Colorado. New York and other states provide their consumers with the same protections, and we believe Marylanders deserve it as well. We thank you for your consideration and in our testimony. We respectfully ask and urge a favorable report of HB 795.
Thank you. We'll go to virtual Bruce Morris.
Thank you, Chairman, members of the committee. I'm Bruce Morris, Director of Government Affairs for Ticket Network. Thank you for this opportunity to submit our thoughts regarding the proposed House Bill 795, the Event Goers' Rights and Accountable Sales Act. We strongly support the bill with amendments. Ticket Network, as Mr. Alston's already told you, is a secondary platform that facilitates transactions. I'm not going to go through that. You have our written testimony. More importantly, I wanted to show here today, because I'm a former legislator from the state of Connecticut, having retired in 2018 as Deputy Speaker. But more importantly to this, or germane to this discussion today, In 2017, while I was deputy speaker, I initiated a bill for ticket transferability in Connecticut. So we've had that bill in place for 5 years now. I'm here to testify to you that we're successful. No one's complaining about the bill. It works well for consumers. And in fact, all-in pricing, something that you've got in your bill here today, our AG just submitted a bill this year. All-in pricing is being recommended in a number of different states. We commend the sponsor of your bill, even more so for what you're doing with holdback transparency. These are in standardizing refund policies. We do have that in Connecticut, but these are really crucial consumer protections. I would also offer to you that bots are important, having an actual mechanism where we're enforcing bots. There's a federal law that prohibits the use of bots. The state of Connecticut even prohibits it, but you need to have enforcement. So I'm here to be able to answer any questions that you as legislators may have from another legislator coming from a state that is already successfully utilizing this legislation. And again, we support with amendments and we're glad to work with the committee. We understand that there are amendments that are already in progress, and particularly the one that had to do with the markup. So any questions, I'm here.
Thank you, sir, and thanks for your service in the state of Connecticut. Seeing no questions for this panel, we'll turn to the unfavorables. I have Tom Cole, Ron Legler, Frank Boston, and Gene Parker.
Mr. Chairman. Mr. Chairman, members of the committee, I'm Frank Boston III. I'm here on behalf of Ticketmaster, which is a company of Live Nation, as well as the Lyric Theater. Respectfully, we oppose this bill. My clients support the ban on bots, but there's already a law in books in Maryland that bans the use of bots. That was passed approximately 4 years ago. We support legislation against deceptive URLs, but this body, this committee, 2 years ago, passed a bill to address that. We supported a law 2 years ago to stop spec ticketing. This committee, 2 years ago, passed a law to stop that. The laws are already on the books. The issue is one of enforcement with the AG's office. We met with them. They just don't have the personnel. And the real issue is trying to provide funding so that they can have someone to enforce the laws. House Bill 795, although we did meet with the sponsor, thank you for that, is basically a non-starter. The intentions are good, but the bill has so many bad provisions that it will give bad actors the ability to further deceive and rip consumers off. We will gladly work with any responsible party to draft good common sense legislation that protects the consumers, the venues, and the artists. For example, we support all-in pricing, but you know, if we do it at the first click, the rest of the industry has to do it at the first click, and I can explain that. Delegate Adams, you're spot on. You look at this bill right here, it says, and I'll go right to it, it says on page 4, lines 20, refund tickets. You go to sell your tickets to the Dallas game, and let's just say it gets in the hand of a broker, and that broker puts it out on another website and sells it for 10 times the price you sold it for. Well, guess what? You have to refund the ticket if the game gets canceled. The intent is good. The bill is seriously flawed. With that, we ask for an unfavorable.
Tom Cole on behalf of IMA Incorporated, the operator of Meriwether Post Pavilion. You have our written testimony. This is a pro-scalping bill. I know we've heard the term reseller, we've heard the term broker. This is a pro-scalping bill. And while they will proffer being here for consumers, what they do is they pass legislation like this, and then they use more sophisticated technology to outperform fans, buy up those tickets, put it out on their service, and sell it for an upcharge. You just heard testimony about price gouging. Nowhere is that more apparent in scalping. They don't have to spend the money on putting on a performance. They don't have to spend the money on a venue. They take all of the money they make from upselling those tickets and they put it into that technology. They put it into websites. And as Mr. Boston said, the Attorney General is not able to enforce the laws we already have on the books to protect consumers. So all this legislation does is take away the protections that venues like Merriweather Post Pavilion have put in place to protect themselves and to protect fans, and puts an arm behind their back and makes it easier for scalpers. As I said, our written testimony is submitted, but I have one instance I wanted to tell you all about. The Revivalists are coming to Merriweather Post Pavilion this summer. Tickets go on sale Friday. If you get out your phone, you can buy tickets from StubHub today. That's what's wrong with the ticket industry. Not anything in this legislation, the fact that people are taking advantage of venues and fans by scalping tickets. We ask for an unfavorable report. Thank you.
Hi, good afternoon. My name is Jean Parker, and I'm the General Manager of Merriweather, the 19,000-seat music venue in Columbia, employing 1,000 people, mostly Marylanders, and providing $70 million in economic activity for the state. We're opposed to HB 795. We've been opposed to similar bills since about 2016. They help scalpers. Despite its title, this legislation is harmful to consumers and interferes with venues' ability to protect our fans. As an independent music venue, Merriweather takes enormous financial risks. We book and pay artists, employees, rent, taxes, licenses, insurance, marketing, upkeep, and security. We know that there are those looking to profit off our work and our risk. Scalpers, or ticket resellers, buy up our product and resell it for sometimes more than 10 times the original price. They do this without any consequences from the state. Our written testimony provides detail about how the anti-scalping laws should be different, but the basic point is that HB 795 hurts what limited ability we have to protect ourselves from scalpers while make it easier for them to rip off our fans. This legislation interferes with bringing top talent to Maryland. We contract directly with artists, and some insist on non-transferable tickets to ensure real fans are in the seats. If we cannot fulfill artist requests, artists like Adele and Eric Church will choose to skip Maryland. Next, let's be clear. A concert ticket is a license, not property. We are inviting people into our space, and we need to retain some level of discretion over who enters, including the ability to check someone's ID and potentially exclude individuals who have breached our rules. We should also be able to deter scalping activity by canceling tickets. Tickets bought using bots are canceled. The same if someone tries to buy 8 tickets when there's a 4-ticket limit. Finally, this legislation will create a huge liability for Maryland venues. As written, if a consumer is sold a counterfeit ticket by a third party due to no fault of the venue, the original ticket issuer would still be responsible for reimbursing the full value of the ticket. We want to work with you to craft a new bill that benefits Maryland consumers and protects Maryland venues. Unfortunately, HB 795 achieves neither of these goals. And just to comment on what Tom had said at the end of his testimony, what that practice is called, what happened this morning, is called speculative ticketing, and it's wrong and it's criminal.
Thank you. For the record, my name is Ron Legler. I'm the president of the France Merrick Performing Arts Center, home of the historic Hippodrome Theater. I just want you to know that every venue in this beautiful state does not want to see this pass. I'll give you a prime example. We were fortunate enough to get Chris Rock to do his show, right? It's so amazing. Sold out in 7 minutes. It's going to go around the world with Netflix. If you go on right now, just Google and put in Chris Rock Baltimore tickets, StubHub, Vivid Seats, Geek Seats, BaltimoreTheater.com, EventTicketCenter.com, GameTime.com, BandsInTown.com, ClosedSeats.com, TicketCity.com, TicketSales.com, TicketPick.com, and TicketSmarter.com all have tickets that are not part of our system. None of these people that's paid $1 to have the show come to town, they don't pay our electric bill. They're not even in Maryland. But what's happening is these people are getting hold of our tickets. We sold the tickets for Chris Rock at $125. They're on sale right now for $1,500. So this is what's happening. Like, you have wonderful venues. You have the people here that will tell you what goes wrong. You only have to come to the venue on a sold-out Les Mis to see that a family that bought speculative tickets don't have really seats. And then they get mad at the venue because like, how did you buy the tickets? We bought them from you guys because it looks just like us when you go to the website. 12 websites before you even get to the Hippodrome. So you guys have to understand, this bill is not friendly to consumers. If there was a problem, you would have had the Attorney General up here tonight saying we got 1,000 complaints about the Merriweather or about the Hippodrome. You didn't, there's no complaints. None. We only lost 1% of our subscription base during the pandemic. We held their money for 2 years. But you know what? They believed that we would bring those shows back when it was time to do it right. We know customer service. We have to make them come back to Maryland. We have to make them come back to Baltimore. So understand, your venue operators in this state are the best in the country. I promise you that. And we don't have issues with people with consumer issues. Believe me, we don't.
Delegate Adams.
Thank you, Chair. And there's no way I know in advance because I just print bills out and see them when they come. So when I give you this example and ask the question, it's you've got Ticketmaster and Merriweather here. Back when I was a kid, I went to a Steve Miller concert. That ticket had to have been, $30, $40. We're talking about like 1992 back then. And let me just say that venue I was talking about, Red Rocks, believe it or not, Steve Miller Band's performing on September 11th, getting a spam call. And a ticket's $127, which when you go from 1990 to now, that doesn't seem like an unreasonable price. I don't detect manipulation of the marketplace. I detect a band that is selling a good seat because I've been there before, and why not go, right? And then when I buy that, like, because we do digital ticketing now, I mean, I feel comfortable with that experience. My question is, one of the pieces of testimony came in that there's manipulation in the market, that Ticketmaster somehow artificially bumps prices because they're holding tickets back. I don't even understand how that would happen. But is there any testimony that would lend itself to that? Because I don't see it just on one raw example that I can relate to.
So real quick before Frank jumps in terms of manipulating the market, the entities manipulating the market are unequivocally the ticket resellers. They are the ones manipulating the market.
I just want to say I have the more folks from Ticketmaster Live Nation here who can specifically answer your question about how the price is set and et cetera. So they're coming behind me.
And as a consumer, Delegate, this passes a sniff test is what I'm saying.
Yeah, Delegate, we actually bring the national tours of Broadway to Maryland, so we set the price of the tickets. The producer sets the price of the tickets. Yeah. The presenter sets the price of the tickets. Yeah. Ticketmaster is just a platform to sell the ticket.
That's what
they don't control the price of our tickets.
All right, thank you.
I'm just going to call you out. 1992, you were a kid. 1992, I was 10. There's no way you were a kid in 1992.
Hey.
Yeah, and let's also set the record straight. There's no crazy demand for Commanders tickets. Delegate Queen.
Delegate Adam, look at the color of the tie. I mean, come on.
Can I say one more thing about 1992?
Thank you, Mr. Chair. I will say, there used to be a demand for Commanders tickets. I'm not re-upping this year, but anyway. But my question, I do want to get over there to Ravens. But anyway, a couple things, though, I want to talk to that the bill talks to that I've not been happy with Ticketmaster on, outside of buying it through Commanders. The all-in pricing and the ability for refunds. That's really been a problem. So I don't know what. So that's a question. And the other question is, you mentioned about the Attorney General, but the Attorney General, and we'll wait to hear from them, have said they support this bill. So we need to talk to that too.
Yeah. So regarding all-in pricing, Live Nation, Ticketmasters, we support it, but let me walk you through it. If we're going to do it up front, right? When you go to click on the button to buy, the tickets in row AA, a center orchestra, and you go and if we put the fees with the cost of the ticket and all there, everyone else in the market has to do it. That's the thing. Because what happens is some other people will do all-in pricing, but that ticket that we are selling for, let's just say face value 100, and then once you get your fees and all, you'll see before you hit click one, it's 125, right?
Maybe like 130, but I'm
all right, let's say 130. I'll go with you. All right, 130. Someone else who's doing it may wait until you're ready to pay at the very end. So you're already there, and then when you hit the final click, oh, wow, here are your fees. And that's an unfair advantage because we put it up front, so our ticket seems like it's $130 in the beginning, where all the way until you get ready to put your credit card number in, and at that point you say, oh hell, let me just hit it. So it just has to, we support it, let's, on the record, we support it, and that is a good thing that's in the bill, but it has to be flushed out and everyone needs to be on the same page. It is a good provision and we have no problem with it.
If I may, the issue that Frank is addressing is that right now it's illegal to have a deceptive URL, but search for Merriweather Post Pavilion. It's the top 2 links. And so you will be able to enforce this legislation against Merriweather, against Ticketmaster, but the entities that are the bad actors, they're not being restrained by Maryland's law. So that's why our concern is the venues will have our hands tied, but the scalpers are going to continue to act illegally to the abuse of consumers. And it'll make it worse because we'll be transparent in our ticket prices, but the entities that you can't enforce this law against will take advantage of it.
Okay.
Thank you, Mr. Chair, and thank you all for coming. So I'll just say, like, you know, we have an issue, right? We got an issue. You know, I feel like I do a lot for my wife, but I feel like I hit the lottery because I figured out how to get Beyonce tickets. So if that becomes more of a struggle in life, getting a ticket than, you know, securing like contractors to do work in my house, right? So like. So we all agree we have an issue here. And I want to go back to what you said earlier, is that we have laws on the books, but they're not working. So you mentioned that the issue, you had a meeting with the Attorney General. So the issue was funding, personnel. Was there further conversation on what we can be doing to enforce the laws that we have? And what does that look like, just based on your previous conversations? I'm trying to understand, like, well, if we got things that if it's not working, then I want to know more about what the solution is.
Yeah, thank you for the question. About 2 years ago, we had the meeting with the then AG, Brian Frosch, and it was a really good meeting, and they recognized the issue. They even said that they are aware of some of the unscrupulous activity, but that they did not have the resources to enforce it. Further, the second part of it is some of the illegal activity is happening outside of the country. So how can they enforce it? But to Merriweather's credit, and not to speak to them, they said, we left the meeting saying that we would provide them of examples, and when we got a chance, we would share it. I think within a month, Merriweather sent over some examples of, deceptive URL spec ticketing, and we sent it to the AG, and they basically said that they didn't have the resources to take this issue up.
Okay.
And so, bots, Senator Feldman put in the bill to step up the enforcement of bots. And for those of you who don't know, that's the robots that and buy up all the tickets right away. And before the average good-paying, kind-hearted consumer gets a chance to buy. And we put a ban on it. I think there was testimony that there's a federal ban on it already, but there's no enforcement on it. So the bad actors are like, they can be out of the state of Maryland, which again, you have state long-arm statutes, but unless you have reciprocity, it's kind of hard to enforce against them as well. But those bad actors just say, so what?
Right.
That's the issue.
Okay, thank you.
Delegate Harrison.
Thank you. A couple of things you mentioned. You talked about the bots, and there's a federal ban on them. Does the FTC or any other federal organization then do they get involved? Can you report them? Do they not have the arm to investigate and enforce their laws? The second question is, you mentioned Ticketmaster has there was another company that you mentioned. Was it Ticket Events or something? It was something else that you said. Is that not a secondary market?
Well, thank you for that part of the question regarding the federal law. Lee Moyer and Ted, who will be testifying from Live Nation, can address the federal laws unless someone here again. But I'm glad you asked that question, because Ticketmaster, because of our branding, we get it all. So if there's a Ticket Net, Ticket Network, Ticket Plus, anything with the word ticket in it, it comes back to us, and trust me, we get everybody coming screaming to us and saying, hey, what happened?
No. My question was, I thought that you said that there was, you mentioned another name. I thought you did.
Live Nation?
No, but I thought you said that it was something that was a subsidiary or another. Is it? I don't know. Maybe a reseller. I don't know.
No. So, to your point, Live Nation is the parent company for Ticketmaster,
Right.
and that's what I said. And then Ticketmaster has verified resale. So if you go to buy a ticket and there's no primary tickets left, there's the resale verified ticket, which means the ticket has been verified and it's good to go. It's nothing unscrupulous about it. That's the secondary market.
So that is not a part of Ticketmaster then, or is it just like a contract that you have?
We provide the platform for. So the best example is I have this tie on, but I'm a Ravens ticket holder, season ticket holder, right? And let's say I want to sell. I can't make the Pittsburgh game, right? So I want to resell my tickets. It goes to the verified reseller, who, oh, by the way, is no longer Ticketmaster at the Commanders or the Ravens. It's SeatGeeks now. But anyway, it goes to, so I go on the platform, I go through the buttons, and I said I want to put it out for X price. I'll say Ticketmaster, we put it out, the Ravens had the contract with Ticketmaster, which is now SeatGeeks, puts it out there, verifies that I am legit, that I am the right person, and then they put it out on their secondary market, which has now been verified. And that's the
Which
platform.
would be SeatGeeks?
It was Ticketmaster, but Ravens went with SeatGeek now. I think beginning April 1, it will be SeatGeek. Yeah, it is April 1. But the point is whether SeatGeek or Ticketmaster, me, being a good ticket holder, can sell it at, fair market value or whatever I think this seat's worth, and it's verified. And so that good faith purchaser can come and know that they're actually going to have a ticket to the game.
So your concern then is that there are other platforms, I guess, that are not verified, and therefore they can be maybe counterfeit tickets or something like that.
Oh, yeah.
Okay.
It happens a lot. Go ahead, Mike.
Okay, no, because we have to keep moving on.
All right.
But the other question that I had was the FTC and the other, under the federal, because Attorney General has already said that they don't have the resources to do this. But if it's a federal law, why is not the federal government and their entities then doing this enforcement? Is that something that's going to come up later? Okay, well, I'll wait.
No, Lee Moyer, who is our national person, can address that.
I'll wait.
Yep.
And by the way, some of us do have to represent the commanders, and so just be kind to us. And I'm not even going to talk about 1992.
All right,
with
that
all of the
concludes.
kids.
Oh, sorry. That concludes this panel. Next, we have Ted Mankin, Lee Moyers, Matthew Harris, and Amy Boss. And while they come up, just for everybody's knowledge, the sponsor of this bill was born in '97. This panel is still against. Ms. Boss is information, she'll go last.
Oh, I'll start. Hi, my name is Lee Moyers. Thanks for having me. I represent Live Nation and Ticketmaster in their Government Relations Department. As background, I'd like to clarify what our platform does and doesn't do. Ticketmaster is a technology service that provides venues, artists, sports teams with a variety of tools to plan and sell their tickets. Ticketmaster does not set ticket prices. It does not decide how many tickets go on sale or when they go on sale. It doesn't control ticket inventory. All pricing and ticket distribution decisions are made by the artists and the teams, and we provide the technical support and tools to implement their visions and their plans. Our most important job is connecting artists with their fans. For that reason, we support many of the consumer protection provisions that are in this bill, such as banning deceptive URLs, speculative counterfeit ticketing, misleading and incomplete pricing information, and bots. We actually think the bill could go further to combat those. However, we strongly oppose provisions that attack artists' rights and make it easier for scalpers to box out real fans. Banning artists from setting resale and transfer terms eliminates important methods artists have used to keep costs low and help genuine fans get seats. For example, artists like Pearl Jam, Ed Sheeran, Paramore have set up fan-to-fan exchanges where fans can resell their tickets to other fans at face value with no additional fees. And this technology accomplished exactly what artists want. In the Pearl Jam example, they played shows in 10 states that permit artists to use this method. Approximately 18,000 tickets per show were sold at face value, with fewer than 10 resale tickets per show listed on the secondary market. However, in Colorado and New York, where laws similar to this bill have been passed, thousands of tickets were available on the resale marketplaces, some priced as high as $7,000 for a ticket with an original face value of $75. This isn't what the artist wants. These tools guarantee lower ticket prices for consumers and prevent price gouging by scalpers. While few artists choose to limit transferability, we believe artists have the right to set their own price and not scalpers. For that reason, we oppose this bill as it is a gift to scalpers looking to get their hands on many tickets as possible at the expense of artists and fans. Thank you.
I'm Ted Mankin, Senior Vice President of Booking for Live Nation. Thank you, Vice Chairman, and everyone here for the opportunity to share my perspective on this bill with you. For over 20 years, Live Nation's worked to put artists on stage and connect them with fans. We believe that the artist-fan connection is the foundation of live entertainment, and the number one thing public policy should protect. As a leading promoter in the state of Maryland, we are responsible for working with artists and venues to provide fans with the best experience possible. We support pro-fan, pro-artist reforms. However, there are aspects of this bill that would attack artists' rights and make it easier for scalpers and bots to box out the real fans. I would like to especially address the provisions relating to inventory disclosure and why that does nothing to help fans but hurts venues and artists. Mandating disclosure of technical information about seat inventories does nothing for ordinary fans who cannot use such data while providing a roadmap for ticket brokers and their bots to target the highest value seats and shows. An example of that was last night I was laying out and looking at the engineering drawings for Bruce Springsteen's upcoming date at Camden Yards. Well, there's a lot of nuanced sight lines, and there's things that only the producer and the venue would know as to what constitutes a good seat or a seat that's even available for sale. A broker can't do that. We can. Presently, event presenters disclose interactive maps indicating how many seats are for sale, the availability of inventory from 1 minute to the next as consumers search for and cart tickets. We conduct engineering studies to ensure fans are getting a good viewing experience for their events. It's an interactive seat map for anyone who hasn't used it. However, every event is different, and production setup varies from an ice skating themed show to a concert with elaborate lighting and sets. Arenas also vary in size and their design. So it's a fluid, what I'm trying to illustrate is it's a fluid process, and sometimes we don't know until the show's actually there. Baltimore has a horseshoe-shaped arena versus most arenas, which are circular. So
Sir, can you
sometimes
please
your
just start
sight
to
lines are
wrap up?
bad. Okay.
Thank you.
One of the things we can do is communicate with the fans directly. Saturday, we had a Boys to Men show canceled at MGM National Harbor in Prince George's County. We were able, through socials and through the direct primary accounts that people purchased the account tickets on, to let them know the show wasn't happening.
All right, sir. We're going to have to conclude.
Okay.
All right.
Therefore, we oppose the...
Matthew Harris.
Good afternoon. My name is Matt Harris. I'm the General Manager of the Fillmore Silver Spring, and I'm hoping to provide some perspective on the negative impacts this bill would have on venues. So in regards to not being able to check ID as a requirement for entry, while the majority of our tickets are digital and purchased online, we often have artist-offered VIP experiences that require physical tickets to be picked up at our box office. VIP purchasers could potentially be out hundreds of dollars if someone claims to be them and we don't verify their ID. I see people who get scammed by secondary sellers almost nightly, and there's no way to verify that without checking their ID. We also often have age-restricted events, such as burlesque events, local beer tasting events, that legally we need to check ID before people enter the building. In regards to requiring a refund, if a ticket fails to conform to the description that we provided, there are multiple scenarios that I see regularly that are out of our hands, but would open us up to refunds, such as a show starting a few minutes late due to technical difficulties, a pre-show meet and greet that pushes the door opening time by 10 minutes. Just this past Friday, we had an artist who was scheduled to go on at 8 p.m. but held his start time for 35 minutes because only 50% of ticket purchasers were in the building. In all these situations, our goal is to improve the artist and fan experience. So, it's my position that we should not be penalized for doing so. As far as providing a refund if a performer cancels or withdraws from an event, we often see this with opening acts. They get removed or replaced on tours frequently. Oftentimes, they're selected by the headlining artist and are not even named in the contract that we and the artist sign. It's also common for these events to go on sale without opening acts even announced. So there's no way to, signify that this person bought a ticket before this opener was announced, etc. In both of these refund scenarios, the artist's earnings can be negatively impacted if their contract is giving them a percentage of net ticket sales, which at the Fillmore is often the case. Our primary goal in this business is to provide fans and artists a positive experience that gets them to come back, and this bill would prohibit us from doing that. Thank you.
Okay, for information, Ms. Boss?
Yes, thank you, members of the committee. My name is Amy Boss, and I'm the Director of State and Federal Affairs at NetChoice. NetChoice is a trade association of leading e-commerce and online companies, including the online ticket platform StubHub. NetChoice supports bringing much-needed transparency to the ticket marketplace. A fair, secure, and competitive marketplace is in the best interests of fans. It ensures that they have greater access to the events they want to experience and can make informed purchasing decisions. In recent years, consumers have faced a growing number of anti-competitive practices in the primary ticket marketplace. These include restrictions on the transfer or resale of sales of tickets, a lack of transparency, and underhanded sales tactics. Customers pay the price for these acts with higher ticket prices and fees, lower quality, less choice, and less innovation. HB 795 introduces a number of positive concepts that would be beneficial to consumers and competition in the marketplace, including refund requirements and heightened transparency. Importantly, the bill ensures that consumers are empowered in the ticket purchase transaction by allowing them to purchase tickets without transferability restrictions. Additionally, it would require ticket sellers to disclose fees. Too often, consumers attempting to buy tickets online are confronted by high hidden fees, which are not disclosed until the very end. However, while the legislation is a great starting point, we respectfully suggest that the proposed draft may not sufficiently accomplish what it is attempting to accomplish or set clear requirements for industry participants and consumers. NetChoice is happy to work with the committee on moving this conversation forward, and it sounds like there are amendments to address some of these concerns as well. Thank you again for allowing me to testify.
Thank you, ma'am. And seeing no questions for this panel, that concludes the panel and the bill hearing. Next, do we have somebody from Delegate Guyton's office here? Come on up. Next, we'll have House Bill 476. Delegate Guyton. Do you have a panel?
Might be one person on Zoom, but he said he was having technical difficulties, so I'm not sure if he made it.
Okay, yep, Michael Pooner?
Yes.
Okay.
All right. Thank you. For the record, my name's Corey, and I'm testifying on behalf of Delegate Guyton. We flipped a coin, and I won, and I got the opportunity to testify in front of you today. So she requests a favorable report on House Bill 476, which is intended to ensure that payments are credited to the debts for which they are intended by the debtor. Current law provides these consumer protections from third-party debt collectors. However, businesses that collect their own debts are not subject to the two provisions that this bill states: that the debt collector cannot apply payments to any debt that is disputed by the debtor, and that they must follow the debtor's stated direction of what bill to apply the payments to. Why is this important? Here's one example from a constituent who faced this problem. The individual received a very large hospital bill, and they had questions about it, filed a dispute, and had a dispute procedure going on. They were then sent 2 bills for smaller amounts. This person wrote checks for the 2 smaller bills that they did not dispute, wrote the invoice numbers on the bottom of the checks, and mailed them in. Later, they were put into collections for those 2 smaller bills that they thought they paid because the collector credited the 2 checks to the larger disputed amount instead. Another constituent, who hopefully we'll be hearing from later, disputed a utility bill from their apartment complex they felt was very high. The next month, they received the bill for their rent and utility bill that seemed normal, and they paid both bills, or so they thought. The management company credited the payments to the unpaid utility bill that was being disputed, not the intended rent and utility bill that they were not disputing, that they wrote the month on the check that they sent in. In both instances, the payments being credited to the disputed debts also put them at risk of concession in their dispute. The idea that if they're making payments on an account, they certainly can't actually be disputing that they owe money. Delegate Guyton would also like to point out the support from this bill from the Human Trafficking Prevention Project and the Maryland Network Against Domestic Violence, because ending unfair debt collection practices is critical in helping vulnerable women and people get out of difficult situations that can often lead to more dire circumstances. House Bill 476 increases protections for consumers and eliminates deceptive and unfair debt collection practices. For these reasons, again, we hope for a favorable report on House Bill 476.
All right, good job, Corey.
Mr. Chair, can I just say thank you very much for
That's
Delegate
good.
Guyton here. Thank you so much for allowing Corey to present this bill. He's worked really hard on it, and I had several other hearings today, and he was ready to go. So I was fighting the crowds to get in, but I appreciate that he was willing to take this on. So thanks so much.
All right, happy to have him. All right, seeing no questions, that concludes this panel. Michael Pooner is not in the waiting room, so we will go to favorable with amendments. Bob Enton.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. I've had several meetings with the gentleman of Corey who just testified about this bill, and we are signed up favorable with amendments. I think the problem with the bill is that it's just, there's no detail whatsoever about what happens, how does the debtor notify the debt collector. And the debt collector under Maryland law is not what you would normally think, a third-party debt collector. A debt collector under Maryland law is the third-party debt collector, but it's also anyone who's collecting their own debt. So if you're in business and you're owed money and you're going to try to collect your debt under Maryland law, you're a debt collector. And my question is, as you know, for whether it's a bank, a hardware store, a hospital, whoever it is, then let's say there are multiple obligations, and it says if the debtor owes multiple debts, makes a payment, the debt collector may not apply the payment to any payment disputed by the debtor. Well, how does the debtor dispute it? Does he send a notice by mail? Is it notice by certified mail? And how long does that dispute continue? How does the merchant or the lender, or whoever it is, the hospital, know that the debt is no longer disputed? Was it adjudicated? I don't think we really have as much of a problem with the notion that the debtor should be able to say, look, apply this to this account. I'm sending in a check, and but the question is, how does the creditor, if you will, who's owed the money, have any idea whatsoever about this? How does he prove it? How does notice sent? I'm happy to work on amendments with the sponsor and her staff, but those are the concerns we have. Thank you.
Bob, do you have an amendment? Or?
No, I think it's something we keep talking about, trying to figure out how far we could go to make this workable. We just don't feel in its present form it is workable.
Okay. All right. Seeing no questions, that concludes this bill hearing. Next, we have House Bill 52, Delegate Foley. Delegate, do you have a panel?
I
I think I should have a panel.
Janet Frank,
There we are.
Jose Flores.
A small panel, Mr.
It's all right. Go ahead and begin when ready, Delegate.
Thank you so much, Mr. Vice Chair and members of the Economic Matters Committee. I know it's been a long day. I'm Delegate Linda Foley, and I'm presenting House Bill 52, Condominiums, Sales Contracts, and Asbestos Disclosure, which would establish the requirement that contracts for sale of condominium units contain certain notices relating to the presence of asbestos. The reason HB 52 is needed relates to the proven impact asbestos has on human health and the environment. For decades, the U.S. Environmental Protection Agency and the Maryland Department of the Environment have documented these impacts. However, you might be surprised to know that according to the EPA, federal law does not require a seller to disclose to a buyer that their home contains asbestos or vermiculite. Vermiculite is a mineral used in construction that contains asbestos fibers. In the context of real estate contracts, a buyer looking at older condominiums might find out about an asbestos issue on the property late in the real estate transaction. This could have serious consequences and could jeopardize the completion of the transaction. House Bill 52 would ensure that asbestos remediation would be disclosed and made available to any potential purchaser of a condominium dwelling well in advance of the actual sale. So first, let me give you just a brief background on asbestos and its associated risks. This information is also contained in the written testimony from the Maryland Department of the Environment. As reported by the Centers for Disease Control, asbestos refers to a class of minerals that naturally form long, thin, and very strong fibers. It has been mined and used in many products worldwide. In the United States, mining asbestos has ended, but asbestos is still present in older homes and buildings. Due to its sturdy properties, asbestos was used to make many products, including insulation, fireproofing and acoustic materials, wallboard, plaster, cement, floor tiles, brake linings, and roofing shingles, just to name a few. Beginning in the 1970s, the United States banned many uses of asbestos, but it is still present in the older materials and is used in products such as automobile brakes and roofing materials. Asbestos may also be present in other commercial products. Disturbing asbestos minerals and other asbestos-containing materials can release microscopic asbestos fibers into the air. Workers and others who have breathed asbestos fibers over many years have developed asbestos-related diseases, including asbestosis, pleural disease, lung cancer, and mesothelioma. I'm sure you've seen the commercials on television. Some of these diseases can be serious and fatal. So now back to the requirements of HB 52. The first requirement that this bill sets forth is a statement indicating whether the seller has actual knowledge of the presence of asbestos at the condo, including a description of the location of asbestos and whether abatement has been performed and when that abatement was performed. The second requirement is a straightforward statement as to whether the council of unit owners of a condominium development has actual knowledge of the presence of asbestos on the site, including a description of the location of the material and the status and date of abatement. Both of these are very common sense and simple requirements that provide necessary information to potential purchasers. The Maryland Department of Environment's Asbestos Division has determined that HB 52 does not add any remediation or abatement requirements to existing state or federal regulations. So on the heels of recent news reports of catastrophic failures by condominium associations to identify and correct unsafe conditions, this simple notification requirement will help keep condominium buyers in Maryland safe from serious effects of asbestos exposure. I urge a favorable report of HB 52. Thank you.
Thank you. Good afternoon, Vice Chair and Committee. Thank you for having my testimony. My name is Jose Coronado Flores. I'm a policy analyst with the organization CASA, the largest immigrant service and advocacy organization in Maryland. HB 52 is important legislation that will address health hazards in condominiums, specifically in regards to asbestos. CASA is invested in seeing this bill pass because we have many members who are renters. And renters not only rent in apartment complexes or homes, but many sublet condominiums. So, and among the top complaints that our members have in terms of injustices is housing conditions, and we have heard of issues with asbestos exposure. Passing this bill will impact our members because it will guarantee that when they rent a unit in a condominium, that it will have some type of report on treatment of asbestos as well as quantities and locations of it. This is a vital information that can make the difference between a renter living in a unit with known asbestos presence and consequential treatment, and compared to somebody living in a unit with unknown, untreated asbestos. We're working to make sure that everyone in the state has housing that is safe and poses no health risks. Asbestos exposure can lead to long-term respiratory ailments like asbestosis and can immediately impact one's weight and fatigue levels. For low-income immigrants, having to take a day off of work to go get yourself checked out in the hospital has major implications. This is why CASA urges a favorable report.
Good afternoon, Vice Chairman Crosby and the committee. Thank you for the opportunity to testify concerning an important priority issue of the Montgomery County Women's Democratic Club. I'm Janet Frank, the WDC's advocate for affordable housing. Our club is one of the largest and most active Democratic clubs in our county, with hundreds of politically active women and men, including many elected officials. Our mission is to advocate for legislation to promote the health and welfare of families in this state and in Montgomery County. WDC urges the passage of House HB 52. The bill would help many Maryland residents by requiring a statement in condominium sales contracts as to whether a property received asbestos abatement and the date it was performed. We know extended exposure to asbestos in residential dwellings can cause families and residents to develop potentially deadly diseases, including lung cancer and mesothelioma. Many factors contribute to whether harmful health effects will occur, including age. The Annals of Occupational and Environmental Medicine reported that children are considerably more susceptible to environmental carcinogens such as asbestos than adults. Children's extended exposure to asbestos leaves them vulnerable to a persistent cough, chest pain, loss of appetite, and other respiratory and non-respiratory diseases. HB 52 would mitigate asbestos exposure by requiring sales contracts to disclose if asbestos had been detected, when it was detected, and whether it was remediated. On a federal level, sellers are not legally required to disclose the presence of asbestos in condominium sales. That is why it is critical for the state to enact this legislation. We ask for your support for HB 52 and strongly urge favorable committee report. Thank you.
Thank you, ma'am. Seeing no questions, I'll go to the virtual Karen Strawn. She's favorable. Go ahead, ma'am, when you're on.
Thank you. My name is Karen Strawn. I am with the Consumer Protection Division of the Office of the Attorney General, and I thank you, Vice Chair, and members of the committee for allowing me to testify. Asbestos causes a lot of medical problems. There can be no question about that. And the problem with purchasing a condominium is you may not know whether or not there's asbestos on the unit itself or in the common elements. And that's why it becomes very important that condominium unit owners and condominium boards, councils of unit owners, are required to provide this disclosure so that people who are purchasing a condominium can know whether or not there is asbestos on the premises, whether it's been abated, and when it was abated, so that they can make an educated decision as to whether to go forward. This will help protect people from mesothelioma, various forms of cancer, and asbestosis, which are critical in today's society, that we protect people from these things. They need to be aware of what the problems are and be able to make an educated decision. And for those reasons, we ask for a favorable report.
Delegate Aarons.
Just briefly, right now realtors have disclosures for so many things, and I wonder why this wouldn't just be another disclosure. We do lead paint, and there's dates specifically tied to when this can and can't be. And the other thing would be, we do home inspections. If you acknowledge you have it, you do the home inspection. I don't understand the need for the bill necessarily, other than I think the realtors should probably handle this with just an additional addendum. Is that so?
Well, I think that may not be so, but my understanding is that it's not required that asbestos abatement be disclosed specifically. And asbestos is so lethal and so damaging that I think it's important for buyers to know whether or not there has been abatement and when that occurred. And the other part of this is the part that Ms. Strong identified, which is in the case of condominiums, you also have common areas that are there, and particularly in older buildings, there may be asbestos and there may not be asbestos, but if you're going to buy into a condo community, you should know whether or not there's been abatement.
Okay, it was just a question. I didn't know if there was a real answer, but thank you.
Thank you.
Okay, seeing no further questions, that concludes this hearing. Thank you, Delegate. Next, we'll go to HB 620, Delegate Barnes.
You sure I'm next? Come on up, Bob. Yeah. Come on, come on, come on. Yep, come on, man. How you doing? The hour is long, and I will not take up much of your time. For the record, who said good? Well, just for that, let me pull all my notes out. I was going to be quick. For the record, my name is Delegate Darrell Barnes. I am here to present a bill that I believe is overdue. And it is a bill that has been before your committee before, and Delegate Shee has brought this bill in a different posture. The same for Delegate Henson in a different posture. But I am here to present on House Bill 620, Corporation and Associations, Annual Reporting, Filing, and Repeal of Fees. Let me first note that I know that most of you all are looking at the fiscal note, but I do believe that the fiscal note is extremely high and is not where it should be as far as being accurate. In 2022, approximately 75,000 LLCs were formed here in the state of Maryland. But also in 2022, 60,000 businesses were forfeited. You not only have to pay back those fees, but an additional $350 for reinstatement fee. In 2021, House Bill 356 was an assessment study done by the Maryland Department of Assessment and Taxation conducted a study. And the study recommended the elimination of the $300 annual report fee. For small businesses and entrepreneurs, $300 is a significant amount of money that can create financial hardships. Removing this fee would undoubtedly promote a friendlier entrepreneur climate here in the state of Maryland. Listen, I'm not going to say anything that has not already been said by those that have presented this bill before me. I know that Delegate Fisher wants to leave. So on that note, I'm just going to say I ask for a favorable report on House Bill 620.
Thank you, Mr. Chairman. Members of the committee, Robert Enton on behalf of the Maryland Bankers Association. We do support the bill. The filing fees can be a burden for small businesses, for LLCs. I mean, you know, if you come to me and you're going to start a business, I'm going to tell you, look, why don't you form an LLC? You can form a corporation. You can form a closed corporation. But you need that to protect yourself, in particular, from liability. That's why people form corporations. And I think that, you know, I don't know about the fiscal note. I looked at it. But it just seems to me for small businesses in particular, for startup businesses, This is a good idea. Those are our customers. They bank with us, and we want to see them succeed, and that's why we think this bill would help them do that. So for those reasons, we favor the bill. Thank you.
And sir, you're just for information?
Technical support from SDOT.
All right.
Yep.
Well, seeing no questions, that concludes this hearing. Thank you, Delegate.
Yes.
Next, we will go to House Bill 686, final bill today. Delegate Queen.
Anybody want to come up so we can get this going? All right, came back.
I'm back. We've been here. I've been watching all these hearings.
Oh, my gosh, see? All the money we could have been collecting now. You were here. All righty. So greetings, Mr. Chair and the members, my distinguished members of the Economic Matters Committee. So although this is a very lengthy bill and it's late in the day, it's actually 72 pages. I promise you the intent and the nature of the changes are very simple. All right, so currently what we have under Maryland statute, the Office of the Commissioner of Financial Regulations licenses non-depository financial service providers, which can include mortgage lenders, debt collection agencies, money transmitters, among other entities. Per statute, any license must be paid on a per branch basis. And also they have to provide locations of the branch. So what HB 686 seeks to do is to modernize this licensing structure and make it more in line with other states where we get rid of this concept of branches and we replace it with a fee structure involving issuing of one license and some other fees that are variable based upon the annual assessment. And so this new structure is going to maintain all the other requirements that are needed for bonding of those entities. It still is going to make sure that all of the disclosure of locations are still provided. It is not going to impact any of the consumer protection laws that already have to be done for financial servicing providers. And so this is just to streamline the licensing process. OCFCR expects that the initial implementation of this bill, due to the current balance that they have in the non-depository fund, we'll see a substantial reduction in their fees. But once the program is fully implemented, which they expect to happen over the next 2 years, they'll relook at what we're collecting and what we need and reassess what's going to be needed going forward. So again, the bill is only lengthy because there are 9 different types of non-depository licensing entities, and so we had to repeat the structure and the rules each place where it showed up in the code. So again, if you have any questions, we have the commissioner here to talk through it, but we promise you this is a very easy and simple bill. So we ask for a favorable recommendation.
No testimony, right? Just here for questions, Commissioner?
I am here to say the delegate did a great job in
did.
presenting the bill, Mr. Chairman, and I know it's the one you've been waiting for all afternoon. So I have nothing else to add.
All right. Seeing no questions, that concludes this panel. Final witness, Chris DiPietro.
Yep, Chris. Come on.
Mr. Chair, members of the committee, my name is Chris DiPietro here on behalf of the Mid-Atlantic Financial Services Association. We are an association of non-bank lending institutions. We are licensed and regulated by the Commissioner of Financial Regulation. We are here in support of the bill. That's all.
All right, thank you. Seeing no questions, that concludes this bill hearing and the bill hearings for today. I want to thank everybody for hanging in there, and I'll see you all tomorrow.
Thank you so much. It was your notes.
Wait 5 hours just to say.